if we have people.
Oh,
There's
yay.
All right, I'm going to wait for some of the attendees to populate briefly, and then we'll get started here in just a moment. Okay, welcome everybody to this evening's meeting for the Community Advisory Council. This is the public meeting for August 1st, 2022. If anybody is in need of Spanish interpretation, it is provided as an accommodation if requested in advance. If for some reason you have not requested it, please send an email to cac@sonoma-county.org. Similarly, if you have a disability which requires an accommodation or an alternative format of this meeting to assist you, please contact the CAC at that same email address or at our phone number 707-565-1534. Can we please have a roll call? I know, Lorena, you're calling in. I will ask Melanie if you're able to do a roll call for this evening's CAC meeting.
Okay. Where is my roll call thing? Councilmember Bailey is absent. Councilmember Barrera.
Present.
Councilmember Estrada.
She appears absent.
I don't see her in the list, so absent. Councilmember Pearl.
Present.
Councilmember Pemberton. Nancy, you're on mute.
I'm present. There we go. Sorry.
Councilmember Rose.
Here, present.
Councilmember Solomon.
Present.
Councilmember Chair Zellig.
Present.
And Councilmember Flores is also absent. She emailed, so.
So it appears that we do have we have 6 out of our current 10 members. So we do have a quorum for tonight's meeting. I just wanted to confirm that we do have 6 present out of our current 10 members. So we're good for this evening on any action. Melanie, has there been any?
I'm sorry, don't we just have 9 members?
No, let me check. 1, 2, 3, 4, 5, 6, 7. 8, 9. Oh, wait, hold on.
You're missing one now that you don't have Nzinga.
We do.
So
We're 6 out of 9.
Thank you.
We're 6 out of 9. Thank you, Nancy. I was looking at that open spot.
Right.
So we're definitely okay for our quorum. Melanie or Garrick, are there any changes to this evening's agenda since it's been approved?
not that I know of.
Okay, great. At this point, then, we are going to move on to the approval of the minutes from our last July 11th meeting. Prior to that, I will open up for public comment. Public comment at this stage is for any item only on our agenda and specific to this agenda item. Members of the public are free to address the CAC. And at this time, we are going to have public comment only on this agenda item, which is regarding the approval of the minutes of July 11th. Are there any members of our public who wish to give public comments related to the approval of the minutes or regarding the minutes from last month? Okay, I see nothing that has been, no hands are raised. So I will close public comments and bring it back to our CAC. I am now asking for a motion to approve the minutes of July 11th, 2022.
I'll move to approve.
Okay, I did hear from Councilmember Pearl. Is there a motion? Is there a second to that motion to approve the minutes?
Second.
Also,
Seconded by Councilmember Pemberton. Melanie, will you please take us through a roll call vote on this approval?
Okay, Councilmember Bailey absent. Councilmember Barrera,
aye.
Councilmember Estrada is marked absent. And Councilmember Flores is absent. Councilmember Pearl,
Aye.
Council Member Pemberton,
Aye.
Council Member Rose,
Aye.
Council Member Solomon.
Aye.
And Chair Zeller.
Aye. Thank you. Okay, at this time, we will move on to correspondence items. We did not receive any correspondence items prior to today that was included with our agenda items. However, we did receive a couple items from individuals who were responding related to our Measure P. It was similar emails to the ones we received before the last meeting, letting us know that they are concerned about the MOUs and the other issues that we will discuss today. The other correspondence that I wanted to address was an email received, I believe it was forwarded to our CAC this evening, specifically from Jim Duffy, one of the members of our community. It is concerning California law AB 1506, which mandates that the Department of Justice investigate all incidents of officers involved shootings resulting in the death of a quote unarmed civilian in the state. It was brought to our attention, as many of you have also heard, that in the past couple days, the sheriff's office and one or more of their deputies were involved in an officer involved shooting, and the sheriff's deputies did take the life of another person. However, we are still waiting to get information about whether that individual would qualify as somebody who is unarmed, or whether what was possessed, if anything, by that individual would count as a deadly weapon and would permit the Santa Rosa PD to continue their investigation as opposed to the Attorney General. So Mr. Duffy's correspondence was regarding that. That was sent to our CAC. And I did respond to Mr. Duffy to let him know that as we get more information about this incident, we will determine whether AB 1506 applies. And if so, would be able to call for a special meeting for purposes of addressing that issue. I will open it up to our panel now to discuss any of these items that have been received. I see Nancy Pemberton, your hand is up.
Yeah, I wanted to comment on your response to Jim Duffy's
Yes.
email. First, I just want to say that I would hope that that's the decision, that whether we do that or not is something that is decided by the whole committee, not just by the chair. I realize that you have the you have the authority to set the agenda, but this is an important issue, and I would hope that we would be consulted. And I guess we are being consulted right now, so I'm going to weigh in. And that is that the statute that authorizes the AG to conduct an independent investigation allows them to do so if there's a reasonable dispute as to whether the civilian was armed. And it seems to me that, given what at least what we know via the Press Democrat tonight, which is that there were 2 gardening instruments and a rock, there might be a reasonable dispute whether there is. And I'm not sure why we would want to wait until an investigation by the Santa Rosa Police Department is completed, or well along the way, if there is a reasonable dispute. And the AG could come in now when everybody's minds are fresh and when the evidence is fresh. So I would suggest that we actually call for a special meeting or propose a special meeting tonight. Thanks.
Okay, and again, the communication from Jim Duffy was a request for the chair to call a special meeting of the CAC for the purpose of us drafting a letter to the Department of Justice requesting that they open an investigation. My response to Jim Duffy said that it is premature at this point to call for a special meeting until we know a little bit more about what items may have been possessed or are alleged to be possessed by the individual who was shot. So as it relates to the correspondence items, I'm not calling for a special meeting at this time. But I do understand that this is a very important issue. I'm not saying we won't call for a special meeting when we find out more. But my response to Jim Duffy which by the way was sent only to Jim Duffy, but apparently shared more widely soon after, indicated that until more is known about the items allegedly possessed, I believe it is premature to call a special meeting. And that is my position as the chair, and I will not call a special meeting at this time.
Okay, I just want to say, Evan, that it was addressed to you and council members. Jim Duffy's email was not just addressed to you.
Oh, I understand. I was talking about my response to Jim Duffy was sent
Okay.
to Jim Duffy.
All right.
Right. No, I understand his email was sent to us and council members, and it was shared with council members. Mr. Sullivan.
Yeah, I just was just curious. So who determines what weapons were present? I mean, so are we saying that the sheriff's office is saying that there was a weapon and that's in dispute? I mean, is anyone making the claim that there were no weapons? Or I just feel like there's a lot of information missing, and I'm curious who makes a final determination about what weapons were present or not.
So Nathan, so right now what we're dealing with is whether, basically discussing the correspondence items. In one of the correspondence items today, Jim Duffy sent us an email indicating that the Attorney General is required to investigate incidents involving officers resulting in the death of unarmed civilians. And it relates specifically to AB 1506, which is Government Code 12525.3. In that, it talks about that if what is a deadly weapon, and it also defines an unarmed civilian. And basically it says that if there is an officer involved shooting resulting in the death of an unarmed civilian, that the state prosecutor shall investigate. Jim Duffy wanted us to call a special meeting to ask for our Attorney General to investigate. At this point, the only information we have is that this individual may have been carrying a hammer and or a pickaxe and or a rock, none of which are inherently dangerous weapons or inherently deadly weapons, but all of which could be considered deadly or dangerous under some circumstances. Based on those, they may be qualifying weapons, meaning AB 1506 may not apply. I've responded to Mr. Duffy that until we have more information about what this person allegedly had, it is premature for us as the CAC to call for an investigation that may be completely unnecessary and may be uncalled for, depending on what we find out was actually possessed by that person.
Right, from whom?
From the
Who
sheriff's
do we-
department.
Okay, that's
Yeah,
what I want to get.
it would, or from any other sources where we are able to get information. But at this point, we're getting it from the sheriff's department, which,
Gotcha.
again, at this point, we've been told hammer, pickaxe, rock. Again, those do not fall within the specific text of the AB 1506, but it says weapons include, but is not limited to, and hammers, pickaxes, and rocks have all been found to have been used as deadly weapons and can be considered deadly weapons. All I've said to Mr. Duffy is it's premature at this point for me to call a special meeting.
Gotcha.
Nancy Pemberton.
Well, I just want to point out that you and Lorena can call a special meeting, or a majority of the CAC members can in writing call
That's correct.
a special meeting. Okay, so we do have the authority to do that. I also want to say that I want to ask you a question. Let's say that the sheriff's department comes back and says these are deadly weapons, and therefore, or the Santa Rosa Police Department. Is that the end? Is that going to be the end of our discussion about this? And alternatively, if they come back and say, no, these are not deadly weapons, they are unarmed, and therefore the AG does have the right to do that, then wouldn't we also, wouldn't we in either of those situations call for the AG to conduct an investigation? Because under one, that would be a reasonable dispute, or under two, there wouldn't be a dispute and they would. So I'm not sure what the hesitation on your part is.
The hesitation is not calling a special meeting until we have more information. I'm not saying we're not going to discuss it. I'm not going to say we're not going to have a special meeting. I'm not saying that we're not going to discuss all of those issues and may write a letter to the AG one way or the other. But at this point, we don't have enough information to call a special meeting as to AB 1506. At this point, the information we've been given, based on all the case law and information known to us at this point, it does not come under AB 1506. So yes, there are other ways to call a special meeting, and if those ways are presented, they will be addressed at the appropriate time. But regarding the correspondence items, we received one from Jim Duffy. It was responded to. There will be no special meeting called for right now.
But you would call a meeting if you would call for a meeting if they determined that it was a deadly weapon, these were deadly weapons?
If there is the need to call a special meeting to discuss something that cannot be addressed on our regular agenda, we will call a special meeting to address that.
Okay, so it's not whether the whether the item will be heard or not, it's whether it will be heard at a special meeting or not.
It's wanting to get more information before calling a special meeting that at this point may not be necessary.
Okay, got it.
Yeah. Lieutenant Cutting.
Yeah, I just wanted to be clear on the process. So in Sonoma County, we have the chief's protocol, which allows another agency to come in and conduct the investigation. The other agency reports to DOJ of an officer involved shooting or officer involved in custody death. The Department of Justice learns of that incident at the time it takes place, and they learn of the circumstances, and it's their decision, it's their authority and their choice as to whether or not and to what extent their investigation will be done. It could be in person right away. It could be they follow and conduct a document review of the investigation conducted by Santa Rosa. The shall portion of that doesn't mean that necessarily they're going to send a team to Sonoma County to conduct that investigation. It is specifically to the incident itself, and they make that decision. So they get notified at the time, and then they follow it remotely most of the time. The new law obviously has changed it to a certain extent to if there's no deadly weapon involved. And you are correct, Nancy, that Santa Rosa makes that determination based on their investigation. However, DOJ has the ultimate authority as to whether or not they are going to be the ones to conduct a further investigation.
Thanks for that.
Yeah, thank you.
Yeah, thank you. That's helpful.
Councilmember Pearl, I see your, yes, Councilmember Pearl, there you are.
So what I'd like to suggest, given that we only meet once a month, if we're not going to have a special meeting, can we make sure that this is on the agenda for the September meeting? Just to make sure there's an item, whether it be to review what's update with what's known or with whatever investigations may be occurring or may have occurred, just that we have an item on the agenda for September for sure.
And I know I just made a note. We'll discuss that again, and we'll add it when we talk about future agenda items. And I agree that we can definitely make this a September agenda item to follow up. We don't want this getting lost at all.
Thank you.
Okay, I will now open up this agenda item topic for public comment. Public comment will be reserved for those individuals wanting to speak only about this agenda item, not other agenda items, and not general public comment. If you would like to give public comment, please state your name when you're admitted to talk. You will have 3 minutes. The first person I see is Elaine Holtz. Can you hear us? Elaine or Elaine Holtz?
We can't hear you.
Can you hear us?
Yeah, I can hear you. You probably can translate.
Okay, I see your hand up.
Can you hear me?
Yes, we can. Go ahead. Thank you.
Sorry, Bluetooth problems.
Oh, no problem. We can hear you.
Great. I just wanted to state that I disagree with the opinion on delaying a meeting to request that the AG investigate. I think that given what came out today in the Press Democrat, I wasn't sure if you were aware of that coming out, because you were saying that you were unsure what he had, and they pretty clearly reported that the Santa Rosa Police Department said that he had a rock in one hand and a couple of gardening tools in the other. And I read what qualifies as a deadly weapon in the state statute, and nothing even comes close to any of those things. So I think we have plenty of stuff to go on, plenty of information to show that this man would be by state law considered unarmed. So I would like to request that you change your mind about not doing that. Thank you.
Great, thank you very much. The next person I will call for public comment is Jerry Threet. Mr. Threet, when you're admitted, you'll have 3 minutes.
Good evening. I just wanted to suggest a couple of things to you on this topic, and I do agree with Mr. Duffy's suggestion to you. One is, in regard to Lieutenant Cutting's statement about how DOJ handles these matters, it is true that DOJ is also responsive to local requests. So it's ultimately their discretion and their authority, whether how fully they may investigate something like this, but local requests do influence their decisions. So I think you should consider that. The other thing is just looking at the statute that we're talking about. I think really the focus in the discussion has been on the wrong thing. First off, we've been discussing weapons when actually what's at issue is whether it's a deadly weapon. It's unquestionable that what was in his hands could be used as a weapon of some sort. The question is whether it meets the definition of deadly weapon. And secondly, it does say that the AG shall investigate under these circumstances when the person is unarmed, meaning he doesn't have a deadly weapon in his possession. And if there's a reasonable dispute as to whether those objects are deadly weapons, then the AG shall investigate. So I think when you look at all those terms together, all the provisions, it suggests strongly that the AG should be investigating this matter, given what we know about it. Yeah, I think I'll just leave it at that. Thank you very much.
Thank you, Mr. Threet. Moving on to the next individual, Bernice Espinoza. Bernice, please go ahead and give your public comment when you're admitted to the room.
Thank you. Bernice Espinosa, an attorney here in town. I just had a question for if the director is going to be doing an audit for this particular death and how that plays priority with existing audits, and if there's the possibility of placing this matter at the forefront since it is the most recent death involved with the sheriff's deputies.
Thank you very much. Garrick, do you want to address briefly whether there will be any audit of this death investigation? You're on mute. You're on mute.
Sure. The Measure P itself and also the MOU, although I know it's controversial, is that IOLERO will not do the investigation until the investigation has been done by the sheriff's office, or in this case, the Santa Rosa. Well, I guess the sheriff's office, possibly the Santa Rosa police, depending on how the sheriff's office does it. But we will not do one right away until those proceedings are concluded. Richard may want to answer this one too. He's going to be a panelist and has his own agenda item, so he may want to do that when he speaks.
Thank you. The next person for public comment is Allegra. Allegra, please go ahead and give public comment when you're admitted to the room. You'll have 3 minutes. I think we may have lost Allegra.
May have lost Allegra.
Yeah, I don't see her hand up anymore. Oh, Allegra, yes.
Okay, hang on.
Hi, thank you. Sorry, I lowered my hand early. But I also just wanted to echo those who have said that it sounds like in this case, an investigation is something that you should go forward with. I don't really understand the delay myself on the part of the chair. This is what community oversight is for. These types of incidents is specifically why we have community oversight, why we have you to protect the people and to serve as a conduit between the community and law enforcement. And I would just ask that you take that responsibility and move forward with any kind of action that you can take so that this gets thoroughly investigated, because this man did not have a deadly weapon and he was unnecessarily killed. Thank you.
Thank you, Allegra. The next person for public comment will be Elaine Holtz. Elaine Holtz.
Hi, thank you for taking my call. First of all, I'm just checking to see if I can get through because the last meeting I had the hand up for quite a while and nothing happened. So now I see I've done the right thing.
Yes, you're through. We can hear you.
I like to say ditto to what Allegra said. And the feeling I'm getting from watching last month's meeting and the month before, the feeling I'm getting is that there's a lot of stalling, let's put it that way, because with this recent shooting, I don't understand why the IOLERO can't have it on their agenda, can't discuss it, and can't have reports on what has been done. This has been done, this is who's here investigating it, and this is what's happening. It feels like there's a fog, like somehow there's a resistance to even IOLERO getting involved. And I saw that the last time I saw that was when you were going to bring up the issue about during the sheriff's race, when the young man that was running, there was a question whether he should have been wearing a uniform or not. And somehow that was stalled. It wasn't discussed. And then when it was discussed, it was way after the fact. And it was like a nothing event. And as long as I've been involved, particularly around the Andy Lopez situation, one of the things that I have found more and more and more is resistance to really doing oversight, a big resistance. And I hope that is not happening. So thank you so much for listening to me.
Thank you. The next person to give public comment, Barbara Grasecki, sorry.
Hi there. Thank you for taking my comments. I just want to echo my agreement with Jim's request. I do think that it seems pretty clear from the Press Democrat reporting that we aren't dealing with a deadly weapon. Those weapons could cause harm, but based on the statute, as I understand it, those are not deadly weapons. I think the other piece was the distance away was significant from the officers. So I don't know that there was any real imminent threat. So I would agree that there's no reason to wait to hold a special meeting, and there's no reason to wait to ask the AG to get engaged, because the longer we go, the memories get a little foggier. And this is a significant issue. We've had too many deaths at the hands of deputies. And I just feel like, the beauty of IOLERO is that's the voice of the citizens getting to the truth. And if the truth exonerates the officers, that's great. We need to know that. But if there's issues that need to be changed within the sheriff's office, we also need to know that, because too many people are dying at the hands of these officers. So I would just exhort the chair to reconsider his position and call for a special meeting and reach out to the AG and get an investigation going. Thank you.
Thank you very much for your comments. The next person to give public comment on this issue is Lee. Lee, please go ahead and give comment when you are able to.
Thank you. Thank you all for your time. I want to echo what pretty much everyone has said and really ask you to reflect on what the voters significantly have asked you to do time and time again. People call in around the subject all the time. And it is outrageous that we have yet another death. It should be abundantly clear that IOLERO should investigate, do an audit. Seems to be very clear that the Attorney General should investigate. And I can't fathom why anyone would not want to do that. That is very suspicious that there would be a reason not to investigate another death. Thank you for your time. I yield my time.
Thank you very much. Bailey, you are the next for public comment.
Hi, thank you for your time. I just want to echo what everyone else has been saying. IOLERO should investigate, the Attorney General should investigate. Seems pretty reasonable to me. Thank you. Yield the rest of my time.
Thank you. And Jim Duffy for public comment. You have 3 minutes once you're admitted.
Thank you so much. I will take much less than 3 minutes. I just want to address my comments to the other people from the community that are listening and remind you all that with Measure P, all these people on the Community Advisory Council are appointed by a supervisor. So they are representing that supervisor. And if one of them or multiple of them are standing in the way of accountability and transparency, I encourage you to call the supervisor who appointed these individuals and say something. Thank you.
Thank you very much. Okay, we will close item number 2 for public comments and bring it back to the panel. Is there anything else from our CAC regarding item number 2, correspondence items?
I'd like to move that we call a special meeting.
Okay.
And I realize that we have to do that in writing, but I don't want to get accused of not having said that in public because of the Brown Act. So I'm going to say publicly that I am calling for a special meeting. And I think that our community has asked us to do that and that we ought to listen to them.
Thank you, Ms. Pemberton. Hold on.
Sarah Zelig, I
Yes.
can't raise my hand,
yes.
but I support the idea of having a special meeting, but I also agree that today is not the day for that meeting. I agree that we need a little bit more information. There is a process that we have to follow as appointees per the Brown Act and all of that. We have to give a 24-hour notice for a special meeting, and we also have to think about the limited resources that we have. This is going to be more things that Melanie needs to do. Yes, it's important, but I think we should call the special meeting once we have a little bit more information. I do not agree that tonight or, within a day is the right timing for this. But I do think that one should be had if we do have more information prior to our next upcoming regular meeting. That is my point.
Thank you, Lorraine. I appreciate the comments. And yeah, for anybody who is desiring a special meeting, please follow the procedures laid out for requesting such meeting. We will now move on to item number 3, the interim director's report. And Mr. Byers, can you please give us your report for today?
Yes, make sure I'm unmuted. Yes, thank you. So let me start with a couple of items that were brought up at the last meeting. I was asked to check on the status of hiring the permanent director. I did that. You might remember the last 2 meetings I've been saying that the schedule has been that it would probably be completed. The process would probably be completed in late August or in early September. I checked on that last week. We're still on, the Board of Supervisors really is still on that same schedule, late August or early September. They're keeping this pretty close to the vest. I really don't have any further details, but I do have that. It's still on the same projected timetable. I was also asked to double check on IOLERO's budget for this, what is now this fiscal year. Last time I said it's approximately $1,900,000, and I did check, and that is the case, approximately $1,900,000 for the fiscal year. Last time I talked about the status of hiring a new, what I'm calling a community engagement analyst. That position has been unfilled since before I arrived in IOLERO in September, and was still unfilled when I became interim director late last January. Hopefully, the word I get today is, just today, is hopefully next week. It's expected next week. We'll see. I've been expecting before. One of the, if you might remember that also 2 meetings in a row, I have complained about the lengthy hiring process for IOLERO. But I've also been saying I'm going to leave that to the permanent director to deal with, but I'm not keeping any secrets from anybody. I'm unhappy with the long process to hire. The status of Measure P, we have a special panelist, Richard Bolaños, who was the main lawyer for the county on this, both the litigation and the negotiations. I'm going to let him talk about the status of Measure P. I did talk about that last time. I do want to add very briefly that there's been some progress since last time. The operational agreement between IOLERO and the sheriff's office has been signed and finalized. From my point of view, as a practical matter, I'm proceeding with implementation of Measure P. Some of the things that have been brought up tonight, IOLERO has more freedom to move on those matters right now. And lastly, you might remember last time Melanie mentioned very briefly that IOLERO has got a vehicle on the way to take to community events, community outreach events, and that vehicle is apparently in preparation. So I'm hopeful that we'll have possession of that soon. And I sure hope that we get that community engagement analyst soon. I will let CAC members talk about a recent outreach event in Healdsburg that I didn't take part in. So that's my report for today.
Great. Thank you very much, Mr. Byers. I will open up now for a panel discussion. Are there any CAC members with questions, comments, or anything to discuss regarding Garrick's presentation?
I just wanted to ask whether we could get a copy of the operational agreement between the sheriff and the county.
I believe it's posted on the IOLERO's website. Is it posted
Is
yet,
it?
Melanie?
Melanie, you're on mute.
I haven't seen it to have it posted.
I
Yeah,
thought it
I
was.
haven't
It should be posted. I'll make sure that it gets posted, and I'll get a copy to you.
Thank you very much.
Thank you.
Appreciate it.
Are there any other CAC members who wish to either ask questions or discuss Garrick's current report, understanding that we have more discussions about the MOUs coming up? Okay, I see no CAC members with hands raised. I will open this up now to public comment. Public comment will be only as it relates to agenda item number 3, the interim director's report. And the first person for public comment is Frank. Frank, you'll have 3 minutes once you are admitted to the room.
Good afternoon. Can you hear me?
Yes, thank you.
Hey, just what is the timeline? I should probably know that, but I don't know what the timeline is.
Are we talking about the timeline for hiring a permanent director?
Yeah.
Yeah, I've told you everything I know, really. It's being kept very close to the vest is a way to say it. So if you want to know more, I think you have to direct that to the Board of Supervisors or to the head of other departments. Because I do not know anything else about that.
So it was never stated that we want to do this year, 2022.
Right now, the best that I know is that we're on track for late August or early September of 2022. I'm hoping there's no delay. Let me tell you, I hope for no delay.
So they're interviewing candidates now.
They interviewed candidates earlier, and I have not made inquiries as to the precise stage that things are in now. I assume, since the timetable has been unchanged for 3 months, actually longer than that, I assume that the hiring process, the people in charge of it, are moving along on the schedule that they had planned. Given how long it takes to get staff for IOLERO, I would be surprised if the permanent director is still in the beginning stages of interviews. But the truth is, I don't know.
Okay, thank you.
Thank you, Frank. Elaine Holtz, you are up for public comment as it relates to the interim director's report. You have 3 minutes.
Last time when you talked about the MOU, you said that you did not know who the attorney was at the meeting. And now this week you're saying that you don't know their hiring practice. And I'm wondering, I'm very curious why you're not being communicated to. Actually, you're supposed to be representing the voters and should be getting all the information. And the other thing that you just mentioned now, you said IOLERO can move forward now, has more movement. And I wish you would explain that a little bit. I mean, you kind of left it out hanging in the air with, what does that mean? Movement in, movement out? I mean, what more protocol have they added? And I'm curious, did you find out who the attorney was that attended the original meeting?
Well, let me speak to that one. I'm not quite sure I understand the question. I believe that I mentioned Richard Bolaños last time as the main negotiator. He is here this time, so and he's that guy. As to the timetable, I wish I knew more myself. And if you want to fault me for not being able to find out more, go ahead and fault me. But it's not that kind of thing. That's up to the Board of Supervisors and to the people in human resources and other departments who are involved in that process. As to moving forward, so as we've been talking here, I've been looking at Measure P and seeing in what areas IOLERO might have an ability to look closer at for example, the shooting that just occurred. I don't want to get ahead of my of the way Measure P is going to be interpreted. So I just want to say I'm taking a close look at that and seeing what I can do. I have been in touch with the sheriff about it. And he's told me a little bit of information, but nothing that didn't come out in the newspaper over the weekend. I'm not aware of the developments today in the Press Democrat.
Thank you. We will now move on to Keith R. Keith R., you will have 3 minutes once you're admitted to the room.
Hi, Keith Reinhardt.
Hi, Keith.
Hi, everybody. Thanks for this opportunity. I'm completely unsatisfied with the director's report. I don't understand why we have a negotiator at all, because Measure P has been exonerated. And I know there's going to be a discussion about that. That's fine. But I just want to say it really does seem like the CAC is, for the most part, except for one notable exception that I can notice, is pretty much a yes man organization to the county. And I'm not happy about that. And I thought the report from Mr. Byers was vague and undetailed, and that's all I have to say. Thank you.
Thank you, Keith. That closes public comment for this agenda item. I'm now going to bring it back to our panel if there's anything further from panel members regarding item number 3. Okay, seeing no hands raised, we will move on then to item number 4. Item number 4 is a continuation from last month, where we wanted some further explanation regarding the MOU negotiations related to Measure P. This evening, to help assist us with that discussion, we do have Richard Bolaños for our discussion, and I will open up now to our panel and welcome Richard Bolaños to speak to us about these issues. Good afternoon, good evening.
Thank you. Good evening, Commission members and members of the public. I can start by providing some general comments and observations around the issues as I understand them. Then, of course, I'm happy to take any questions from the commissioners and for the public. So let me just start by speaking to the general question and concern as to why the county, and more specifically IOLERO, negotiated with the labor groups in the first place over Measure P. So as we noted in the FAQ that we published, there are 3 reasons for the negotiations with the labor groups. The first, Measure P requires it. Measure P requires that there be implementing protocols that need to be created between IOLERO and the sheriff regarding the implementation of Measure P. And because the protocols affect working conditions of the represented members of the bargaining units, state law requires negotiations of those protocols before they're implemented. The second reason is, as I'm sure everybody knows, over a year ago, the Public Employment Relations Board invalidated 11 amendments of Measure P. Negotiations with the labor unions is necessary to reinstate those amendments. The third reason would be that there are significant areas of ambiguity and areas of Measure P that do not address how to implement the will of the voters specifically. And so the negotiated agreements with the labor groups were intended to provide procedures, necessary procedures, for the implementation of Measure P. As the FAQ notes and the chart that we've attached to the FAQ identifies, all 11 amendments that were invalidated by Measure P have now been fully effected through the negotiated agreements with the labor groups. And that's significant given the effect of the litigation that I can also speak to here briefly. When the Public Employment Relations Board invalidated a significant part of Measure P over a year ago, the County Board of Supervisors determined that first it would appeal PERB's decision because we felt that PERB's decision was legally incorrect. But the second main concern was how do we get into effect those provisions as soon as possible so that the will of the voters would be fully implemented. And the County Board of Supervisors determined to take a two-track approach to address that. The first track was the litigation. The second track was to meet with the labor groups and meet and confer over those invalidated provisions. As the letters of agreement indicate, we have completed those negotiations with the labor groups. As to the litigation, coincidentally, on the same date that the letters of agreement were completed and posted for the public's review, the Court of Appeal in San Francisco rendered its decision on June 23rd. And in that decision, the Court of Appeal found that the county's first argument that PERB had incorrectly applied the law as to a significant part of Measure P was correct. And the Court of Appeal remanded the matter, ordered the matter remanded to the Public Employment Relations Board for further proceedings consistent with the court's decision. The Court of Appeal also agreed with PERB on the issue of the county's responsibility to negotiate the effects of implementing Measure P. And on a third point, the Court of Appeal agreed with the county that the Public Employment Relations Board exceeded its authority by its remedy. And to address that point, the court also remanded the matter. The significance of that is proceedings with PERB addressing the invalidated provisions of Measure P are not complete. And we've also had information brought to us indicating that PERB may very well appeal or seek Supreme Court review of the Court of Appeal's decision, which would further extend the litigation. But for the letters of agreement that are in effect now, that have now put into effect the invalidated provisions, those 11 amendments would still be subject to the litigation of PERB and would still be bound up, if you will, and subject to the process of litigation. And of course, that's the outcome we wanted to avoid. And as the interim director notes, with the letters of agreement, IOLERO is presently fully empowered to implement all of the provisions in the ordinance, as well as in the letters of agreement, as well as in the operation agreement that was just noted by the director. Let me speak now to some specific areas of concern that I have read that have been brought forward by the community. First, there's a concern about what is identified or referred to as a conflict provision in the letters of agreement. A conflict provision which indicates that in the event of a conflict between the letters of agreement and Measure P, the letters of agreement will prevail to the extent permitted by law. That conflict provision is intended to acknowledge that Measure P must be read with the Myers-Brown Act, the government code that allows for affected labor groups to negotiate working conditions. The law that's been established over a number of years requires that both laws, Measure P and the duty to bargain in good faith with represented groups, must be balanced and harmonized to the extent possible. If there's a conflict between the procedures that are required under the Myers-Brown Act to implement Measure P and the provisions of Measure P, the courts have weighed in, the California Supreme Court has weighed in, that those Measure P provisions must be implemented in accordance with the procedures that are spelled out in the MMBA. The decisional law also notes, however, that if there's a conflict between substantive provisions, in other words, if there's a conflict between what a negotiated agreement provides as far as IOLERO's authority and Measure P, then the substantive provisions of the ordinance may very well prevail, again, as permitted by law. So the conflict provision is intended to just affirm that the letters of agreement will be read with Measure P, and both Measure P and the letters of agreement will be read consistent with state law. The second concern that was identified is referring to IOLERO's whistleblower authority. And concerns have been raised that the negotiated agreements in some ways restrict IOLERO's authority as established under the ordinance. We would note that the letters of agreement incorporate the exact language from Measure P, and it establishes that IOLERO is serving as both a receiving and an investigative agency for whistleblower complaints brought against employees of the Sheriff's Department. The provisions in the letters of agreement that are cited and are presenting concerns to the public deal with the authority of IOLERO to refer whistleblower complaints to the appropriate enforcement agency. This is necessary because Measure P does not establish IOLERO or doesn't provide IOLERO with any enforcement authority. It provides that IOLERO is authorized to receive and investigate whistleblower complaints. The letters of agreement do not in any way restrict IOLERO's authority to discharge those enumerated powers in the ordinance. The next area of concern deals with death in custody. The language in the negotiated agreement is from Measure P. We read Measure P as requiring that there be an investigation that is conducted by the Sheriff's Office, over which IOLERO would have the authority, depending on the basis for the investigation, to conduct an independent investigation. And there are specific grounds for doing so. There's the authority to conduct an independent investigation when IOLERO has determined that the sheriff's investigation is incomplete or in some ways deficient. There's also the authority to conduct an independent investigation where there's been a death in custody or a death at the hands of a sheriff's office employee. Again, the ordinance provides that IOLERO's authority derives from the sheriff's office's investigation of that matter. And again, the language in the letters of agreement do not degrade that authority and in fact carry forward that authority. The next area of concern dealt with access to personnel files. The negotiated agreements establish procedures by which IOLERO will access the investigative files of the Sheriff's Office. This is necessary because, again, IOLERO is not specific as to procedures to access files. But very notable here is IOLERO, or more specifically, the letters of agreement, do not disturb Measure P's authority, and in fact, the mandate in Measure P, that the Sheriff's Office provide IOLERO with direct, unfettered access to information in the Sheriff's Office in order for IOLERO to conduct an effective review of complaints and investigations. The negotiated agreements do not at all affect the provisions in the ordinance that establish general authority for IOLERO to have that access. And it does not in any way disturb the mandate of IOLERO that the sheriff grant that access. And that was one of the concerns, that the letter of agreement was being read to allow the sheriff to deny access. And that is not correct. That is not what's in the letters of agreement, and that's not what's in the ordinance. The final point I'll address was a concern over no sunset provision in the letters of agreement. The concern that if there's no term in the letters of agreement, that the labor groups can refuse to make any changes to the letters of agreement and therefore restrict the county's ability to make changes to the letters of agreement. Having no term in the letters of agreement means the county has the authority to propose changes to the negotiated agreements at any time, subject only to the meet and confer requirements of state law. There is no duty to agree to those changes. There's simply the duty to negotiate in good faith. And once the state law procedure for negotiating in good faith is completed, then the county would have the authority to implement changes, even unilaterally if that's necessary, to the letters of agreement. And so rather than have a term that could limit the county's ability to make alterations and modifications to the letter of agreement, the lack of any term allows the county to make those changes upon notice and providing the affected groups the opportunity to meet and confer. So those are some general comments and observations. I'm happy to answer any questions the commissioners and or the public may have. Thank you.
Thank you very much. I will at this time open up for our panel discussions. If you do have any comments or questions, please raise your hand. I'll call on you as they pop up. Councilmember Pemberton, please.
I'd like to just find out whether anybody else has questions first.
Sure.
Because if the others do, I know I speak a lot and I want to give other people the opportunity. But I am happy, but I do have some questions, obviously.
Sure. Let's see. Is there anybody else who wants to speak before Nancy and ask any questions or follow up with what was just given to us? Otherwise, we'll turn it over to Nancy and that may foster some more.
Okay, I actually have several questions, Mr. Bolanos.
Go ahead,
Nancy. Yeah, okay, thank you. I have several questions, and I guess the first one is, as part of the negotiating with the unions, now that the letters of agreement have been signed, have the unions agreed to withdraw their PERB complaint?
No, they've been approached with that idea, but what has happened since the Court of Appeal issued its decision, PERB has gone to the Supreme Court and filed a request for depublication of the decision. And we are told by the labor associations that if PERB's request is denied by the Supreme Court, that PERB will file an appeal. So the labor groups with the possibility of PERB appealing are indicating that they're not prepared to dismiss their complaint at this point. We have requested that through a stipulation, but they've declined.
And if they had, would PERB still have the power to, or the right to appeal if the complaints were withdrawn?
Well, it's a very interesting legal question. The way we look at it is right now, PERB has the right to seek California Supreme Court review. And they would be the moving party in that respect. If the labor groups and the county came to PERB and said, we've reached agreement on all of the issues, there's really no ripe legal controversy, and we're asking for the matter to be withdrawn, it would put PERB in an interesting position, and we're not quite sure how they would respond to that. But unfortunately, we haven't reached that point because the labor associations have declined to consider a stipulation pending the California Supreme Court's action on PERB's request.
Okay. I understand and I'm going to sort of work backwards. I understand your claim that no terms means the county can come back anytime and seek negotiation. They could do that with an agreement that had a time limit on it, couldn't they? They could go back and say, we'd like to meet and confer on this. And it would be up to then the question would be whether the deputies were bargaining in good faith.
Well,
yes or no?
Not necessarily. If there was a term provision in the agreements, typically with a term provision, it's also what we call a zipper clause. A zipper clause means that if the parties have put a term to the agreement, that the parties have no obligation to open the contract, open the agreement for the term of the agreement, unless they do so by mutual agreement. And the reason we would not want to have that here is that one party could say, we don't want to entertain any changes to the agreement. And therefore, we're declining your invitation to meet and confer. And the other party would be restricted by the term language. So not having the term in the contract means you have no zipper provision, which means you have no restriction on the ability to propose changes to the agreement at any time.
Okay, thank you. The next question, and again, if anybody wants to jump in or interrupt or ask a question while, I'm happy to take second, to back off, but
Nancy,
had
I
some
have
other
questions too, Nancy, but I wanted you to go first, so I'm happy you're going first.
Okay.
I have
So
questions.
I'm trying to understand, you said that nothing in the letter agreement it takes away the sheriff's obligation to respond to requests from IOLERO. Yes or no?
Yes, correct.
So why doesn't the agreement say that? It says that they have the power to, that IOLERO can request something, but it doesn't put any obligation on the sheriff. It's silent on that issue.
So when we're negotiating specific provisions with the labor groups, and we're operating under what's referred to as enabling legislation, in this case, Measure P is enabling legislation. It establishes a lot of rights and obligations, but it doesn't establish all of the procedures that are required to affect those rights. As a general rule, you don't want to put anything more in the agreement if the ordinance that you're operating under speaks to it. And so right now, if you read Measure P, and specifically it's 2-394 subpart E, that in that particular amendment of Measure P that the voters approved was not affected by PERB. PERB did not touch that particular provision. That provision, very specific provision, provides that the sheriff coroner shall cooperate fully with IOLERO by providing direct, unfettered access to information in the sheriff's office in order to facilitate IOLERO's receipt, review, and audit of complaints and investigations. And so we had no reason to attempt to put that into the letter of agreement because that authority is well established. What we did need to do is address procedures so that access to the sheriff's investigative material would be done in a procedurally correct way. And let me just add to this point, peace officer personnel records in California are strictly regulated by law, by statutory law. There are provisions in the penal code, there are provisions in the evidentiary code, evidence code, and there are provisions in the government code that establish as a general rule, peace officer personnel records are confidential and can only be accessed through certain procedures that are established by law. And so IOLERO is subject to that law. If you read the ordinance, it makes it clear that IOLERO is subject to all applicable constitutional and statutory provisions. So for IOLERO to access the sheriff's files, it must do so in a way that comports with those other statutes. And so the procedures that we put into effect now do just that. It authorizes IOLERO to have that access, and the labor groups have agreed to provide that access. And the agreements were designed to comport with not only Measure P, but also the statutes and the case law as well. There's a lot of decisional law out there on peace officer personnel records.
But actually, the letters of agreement have two different places where this is addressed. One is in subsection, B2, it says during the sheriff's office investigation, the IOLERO director may contact the sheriff's office and request access for the purpose of monitoring the sheriff's investigative process. But then it says under section 5 that the sheriff's office will provide, let's see, will that at that point, IOLERO will be granted access to the file. So I'm reading this as suggesting that during the sheriff's investigation, IOLERO doesn't have access to the sheriff's information. Because I don't understand why you would have those two different provisions, one during the investigation and another at the completion of the investigation, unless you were suggesting that the sheriff had different obligations at different points and IOLERO had different power at different points.
Yeah, so I would offer on that specific point that the letters of agreement are intended to establish process for IOLERO's audit, review, and analysis of sheriff's investigations. And that's what the procedures speak to, that area of IOLERO's authority. It doesn't affect or limit, unless it's addressed in the agreement, it doesn't affect or limit the general authority in the ordinance. And the general authority in the ordinance is, there's a lot of authority in the ordinance that's outside of the letters of agreement that have not been disturbed or even addressed by the parties' negotiations. Those provisions are in full effect. And
But explain to me why those are two different, why in one section during a sheriff's investigation, there's nothing about the sheriff's obligation to grant access. And it is only at the end that the procedure it says that the sheriff must grant access. In the context of IOLERO conducting an independent investigation, this process would mean that the sheriff could impede that independent investigation until they were, quote, done with their investigation at whatever point they decide it would be completed.
Well, to the general concern about the sheriff's office impeding an IOLERO investigation, the ordinance is the authority that would preclude that or prevent that. The ordinance requires IOLERO and the sheriff to operate in a cooperative and collaborative manner generally. And then there's more specific authority that mandates certain things on the part of the sheriff's office under the ordinance. And as I noted, there's that general authority that IOLERO has access to sheriff's office information. But more to the specific question you're raising, the ordinance, Measure P, is specific as to when IOLERO has independent investigative authority. And we're going from our reading of the ordinance. And of course, reasonable minds can differ and offer different interpretations. The county has read the ordinance, has read Measure P on the issue of IOLERO's independent investigative authority to be delimited by the language in Measure P. And more specifically, what it provides is you start with 2-394, subpart B, 2, which is where IOLERO's authority to review, audit, and analyze administrative and public complaint investigations in mutual coordination and cooperation with the sheriff coroner. That's the authority that's granted. And then under that general grant of authority are a number of areas enumerated in the ordinance as to the types of complaints and the types of investigations that IOLERO has the authority to review, audit, and analyze. That's the general authority. With respect to independent investigative authority, if again you read the ordinance, it derives from the sheriff's office investigation in each area where it establishes that independent investigative authority. So we read the ordinance with respect to independent investigative authority. as requiring there to be a sheriff's office investigation that IOLERO is reviewing, auditing, and analyzing. It just so happens by the vote of the people for very specific types of investigations or matters, IOLERO has the authority to independently review that investigation. And
No,
now more
no, I'm
specifically,
sorry. Mr. Bolanos, it doesn't independently review. It can independently investigate, and that is a big difference.
independently investigate. That I
I mean,
didn't mean to
reviewing some
suggest
work,
that-
reviewing is something that is done after something is completed. Independently investigating is something that happens independently of what the sheriff is doing. They may have to cooperate in order to do it. But my understanding of Measure P is that they can both be conducting their investigations simultaneously.
That's not how we read the ordinance.
I can tell that. I understand that. Let me move on to the whistleblower. Well, actually, let me
Actually, wait, can we dig into that a little bit more?
Yeah, can I just ask one other question about it, and then I'll let you do that. And that is I don't understand why these issues are actually in these letters of agreement with the unions rather than with the sheriff. What we seem to be talking about right now is the timing and the extent to which IOLERO will have access to information and able to independently investigate things. I'm not sure, I don't understand why those provisions aren't something that would be in the operational agreement rather than the letters of agreement with the deputies.
Right, good question. So the operational agreements establish what we would see as the general authority, the protocols that Measure P requires the sheriff and IOLERO to jointly create. Because PERB invalidated 11 amendments of Measure P, the protocols that would apply to the two labor groups that brought the unfair labor practice charges, the Deputy Sheriff's Association and the Sonoma County Law Enforcement Association, those two labor groups, those 11 amendments by operation of PERB's ruling would not apply to them, or null and void as to those two groups. So he had the very difficult situation, untenable situation really, where you have Measure P fully effective as to some county employees and not effective as to other county employees. And that situation was the one we had to address. And because PERB invalidated those provisions as to those two labor groups, we had to have meet and confer sessions with the labor groups to reinstate those provisions. And that's why you have a general operational agreement, and now you have a more specific implementing agreement with the labor associations.
But they were done in reverse.
Yeah.
There were, I would say the operational agreement discussions were taking place between IOLERO and the sheriff, and at the same time we were pursuing discussions with DSA and Scalia. And let me just also note, the process took a while because of the complications presented by the litigation. And the labor groups felt that they were under no obligation to negotiate with the county while the litigation was pending. And they initially sought an order from the Court of Appeal by filing what we call a request for injunction to stop the negotiations. And the Court of Appeal denied the request. And I would submit that but for the Court of Appeal denying the request, or granting, worse yet, if they granted the request, then the provisions now that are in full effect would be remain subject to the litigation that, as I've noted, is not complete.
Okay, I think Nathan and Max both had questions, so I'm gonna leave my hand raised because I'd like to come back.
I
Okay?
just
Thank you.
wanted to address,
Nathan,
you know,
go ahead.
oh, no, you go. You can
Oh,
go.
no, I was going to call Nathan. Go ahead.
Okay, I just wanted to thank you, Richard, for joining us tonight. You've mentioned a couple times now that the intent of Measure P was somewhat ambiguous. So in that scenario, I would imagine you must have called on the crafters of the legislation to clarify the questions you might have had. Did that happen?
Well, first, I didn't say the intent was ambiguous. The ordinance has areas of ambiguity that do not spell out the procedures. I mean, let me give you an example. The Whistleblower Authority. The Whistleblower Authority establishes IOLERO as a receiving and investigative agency, and some general provisions around confidentiality and no obligation to report whistleblower complaints to the sheriff's office. IOLERO was completely silent on how, Measure P is completely silent on how IOLERO will conduct a whistleblower investigation. So without procedures to conduct an investigation, you have to have procedures. So that's an example of where IOLERO establishes general authority. The specific procedures need to be put into effect. And under law, specific procedures that affect working conditions, which is the case with this IOLERO Whistleblower Authority, those procedures must be negotiated before you implement them.
So would you say you were negotiating on behalf, like you were hired by the Board of Supervisors, is that correct?
Correct.
Okay. And what was your direction from them as far as what you were to do? Could you briefly describe that for us?
Well, I need to honor the attorney-client privilege in terms of closed session communications, but
Sure.
as I noted in my opening remarks, when PERB invalidated 11 amendments of Measure P, the board was determined to get those amendments into effect as soon as possible. And the hard reality was that litigation, which was perhaps the direct approach to say, PERB, you got it wrong and you need to get it right.
Right, and PERB did get it wrong, right? I think we all agree that PERB was incorrect in their initial stance. Is that correct?
That certainly has been my argument all along. Yes. Okay. And so that litigation process was going to take time. The nature of litigation was, it's still going. Here we are, a year after, and now we're subject to remand proceedings, which means it's going to go on for another number of months. So the board was determined to address those amendments and get them back into effect, appeal the decision. So we reserved all of the rights that we felt we had with respect to PERB's decision, but get those amendments in place as soon as legally possible. And that was the second track that the board authorized us to take, was to sit down and meet and confer with the affected groups as required by law to get those invalidated provisions put back into effect.
Okay. And you said, and the agreement itself was signed on, did you say June 23rd?
The agreements were posted on June 23rd.
When were they signed?
They were signed on, the board authorized the execution of the agreements, and the agreements were signed in July, the first week of July.
And the appellate court decision came down, what date was that?
June 23rd.
So in other words, the PERB decision was invalidated, right? Their whole opinion was basically thrown out by the appellate court in the end of June, and then this work continued through that first week of July until it was signed, that agreement, the MOU. Is that right? I'm just trying to basically get the timelines right here. So
right. So it's not correct to say that PERB's decision was completely invalidated. The Court of Appeal, there's three parts to the Court of Appeals decision. The first part is where the court agreed with the county that PERB was wrong, conducted an incorrect legal analysis of the county's duty to negotiate putting certain amendments on the ballot with respect to the decision to put those amendments on the ballot. The court agreed with PERB and the labor associations on a second point that to the extent the implementation of Measure P affected working conditions, they cited specific provisions in the Measure P that affected working conditions. The county had a duty to meet and confer before that decision was put on the ballot, before those amendments were put on the ballot. So PERB upheld part of, the Court of Appeal upheld part of PERB's decision. And then the third point is the remedy. They issued a remedy that invalidated provisions, as we know, of Measure P. And the court agreed with the county that PERB exceeded its jurisdiction and authority when in how it fashioned its remedy. And the upshot of all of that was the court remanded the matter to PERB to conduct further proceedings. And that's where we're headed once the appeal is resolved, but the appeal is now potentially subject to review by the California Supreme Court.
Okay, and I'm just looking at your website here. Your focus apparently, just from the law firm's LCW's website, is very heavily focused on labor law, negotiations, administrative law proceedings, et cetera. So it seems like that's your expertise. Is that a fair statement?
I think that's a fair characterization of our website. Yeah. Yes.
So then, and that makes perfect sense. I just am curious, like, to what degree were you in these meetings representing the interests of IOLERO versus the interests of the labor concerns on the part of the county? Who was there representing IOLERO, I guess?
So I was asked to represent the county, and more specifically the county's department, IOLERO. And the county's caucus team, which again, we put this information out in our FAQ, the county's caucus team was made up of myself as outside counsel, representatives of the county's HR department and labor relations division, IOLERO, the interim director was consulted, counsel for IOLERO from the county counsel's office, and the sheriff's office. Representatives of the sheriff's office and counsel for the sheriff's office were consulted at the place and time where three-way negotiations were required. We were not representing the interests of labor. Labor had their own attorneys representing them in the process.
Okay, thanks. That's it for me for now. I'll let Evan, I'm sure you have questions as well.
Thanks, Nathan. Let's go to Max Pearl, if you have questions or comments for Mr. Bolaños or part of this discussion.
Thank you. I have a nitty-gritty question about the whistleblower provision. I understand that, I'm not a lawyer, so I'll tell me this is a little bit over my head, but I do understand that you said that Measure P was a little bit not clear about the procedural process for those investigations, and I get that. But there's a piece of Measure P that's important that seemed to be removed from the agreement, which is about that whistleblower complaints did not need to be reported to the sheriff. And that piece is really important, because any whistleblower you would want that to be confidential to the sheriff's office. And if anyone is in the sheriff's office, they should be able to whistleblow without having any that get back to the sheriff. And
right.
So I want to find out what specifically because it says whistleblower complaints will go to the appropriate enforcement agency. So in terms of that, like, what does this agreement say about that particular issue?
Right. Again, very good question. So as I didn't mean to suggest that the ordinance was ambiguous as to whistleblower procedure. It's silent as to whistleblower procedure. There's nothing in the ordinance that directs
Fair enough.
the steps, right? But it's very clear that IOLERO was created or is now empowered to be a receiving and an investigative agency. And so the way the language in the negotiated agreements was designed was to set up a process for intake of whistleblower complaints. And let me just add as an aside, one step that will need to be taken that we've talked with IOLERO about early on in the discussions is that we'll need to have notices that need to go out to the department's employees to confirm and provide the necessary notice of the rights that they now have under Measure P to file a whistleblower complaint. So that's a step, that's an administrative step that'll need to be taken. But back to your question, what we also saw as lacking in Measure P with respect to whistleblower is that it does not establish IOLERO as an enforcement agency. And so it's critically important that once a whistleblower has brought forward a complaint and that matter is determined to be a qualified whistleblower complaint, that it be referred to the appropriate agency that can enforce the complaints that are brought forward, and it's done in a way that recognizes the confidentiality of whistleblowers. The language, I would admit on that point, that could be clearer, and that could be, we could restate that that IOLERO would not be referring matters back to the sheriff's office. And I would just say that that would be the way we would interpret it. You would not be, the sheriff's office would not be an enforcing agency with respect to complaints brought against the sheriff's office.
Okay, that's, I mean, I guess more clarity in the language would be fabulous. Yeah.
Thanks,
It would really
Max. Tom, let's hear your comments or questions, and then I'll go back to Nancy. I see she still has her hand raised for follow-up.
So very quickly, Nancy, for Councilmember Pemberton, I can't say you're speaking for all of us. You're certainly speaking for me. So take as long as you want, because this is something of interest to all of us. Mr. Bolinas, this came up last week, and hopefully maybe we can get a high-level answer to this. Assume an event happened over the weekend, and people are wondering, how did this sheriff's deputy shoot a guy holding a rock? At what point the sheriff is going to investigate? They're going to turn it over to Santa Rosa to investigate. IOLERO, I believe, can be listening in on the investigation or hearing what's going on. But the deal you negotiated, when does someone have to tell the general public, these are the facts that we've now found, we've investigated? And then IOLERO is going to look at the report and say, we either agree with this report or we think there's a cover up and they need to do a whole lot better job. Can you give a timeline as to when all that happened? And then when does the IOLERO report get out to the public? And how are we advised? And we're the public, so it can't be confidential. But how's the CAC advised as this whole process going on as to what's going on? So we don't sit here 6 months from now going, gee, we'd really like to answer your questions, Mr. and Mrs. Public, but we have no clue. So can you just give us the timeline you think, or the timeline you negotiated?
So in terms of a timeline we negotiated, I would say we didn't negotiate timelines. We negotiated a procedure that speaks to the process whereby matters that are subject to an internal investigation by the sheriff's office, either through a public initiated complaint or through the department's own initiated complaint, go through a process where the sheriff's office conducts its required internal review, administrative review, and that goes through a process. And when it reaches a point of completion and it's certified as complete, then that matter gets referred to, in the file gets referred to IOLERO.
I don't mean to interrupt, but maybe I didn't answer my question or ask the question properly. The people want to know what's going on. Based on what you know about this whole process, When do the people learn what's going on? And I'm more interested in that than the exact way the process works.
So when do the people know? I'm sorry, I'm just gonna have to ask you to be more specific. When do the
Sure.
people know what's going on?
Okay, if we're the CAC, there's an investigation into an officer who shot a guy with a rock. When will we know, was there something else involved? Did the guy with the rock threaten another deputy and the guy that shot him was saving a life? When do we know the facts? Or how does this, we're clear on the whole process, but it seems like the process is leaving the public out of knowing what's being developed during this time until the investigation is totally complete. IOLERO's done a total investigation of the investigation. And then IOLERO at some point, a year maybe from now, writes a report.
So I'm not going to speak to the incident on Friday because I know nothing about it. And I'm certain it's not my place to be advising IOLERO as to its rights and obligations. That's not my role here in any event. But I will just speak generally to the process again, is that it contemplates that there be an investigation by the sheriff's office, and that would then be referred to IOLERO once it's completed. And throughout that investigation process, IOLERO has certain rights and authorities that are spelled out in the ordinance. In terms of when the public can be provided information about the event, this is where state law comes into play as well, in that Measure P has to be read with all applicable state statutes and constitutional provisions. And there are provisions in the law, in the government code, that speak to public right of access and public information pertaining to peace officer use of force matters. And so I would just offer the specifics. I can't tell you because I don't know what any of the facts are, but there are provisions in the law that authorize the disclosure, in fact, require the disclosure of information to the public regarding a peace officer involved shooting. And those provisions would be read with Measure P, would be read with the letters of agreement. And I would just say that the state law will generally occupy that area because that's a state law that governs the public's right to access.
Great, thank you. Let's open up to Lorena. Vice Chair Barrera, I see your hand raised with your phone.
Awesome. Thank you, Chair Zelig. So my question is related to the whistleblower part of this whole thing. I guess I'm a little confused when you stated that the language that was included in Measure P didn't state like a process for the intake and what to do with any whistleblower complaints that were received by IOLERO. And I wanted to know if IOLERO was ever contacted regarding that, because I guess in my mind, when we put something on like the ballot or even when we make policy recommendations to the sheriff, we don't detail how, like step by step, how something is going to be done. We just give like a general recommendation. So I guess that's kind of how I visualize this would happen after being approved by the voters, that IOLERO would then establish kind of like the procedure of the intake of whistleblower complaints. And if we were not made aware of that, then how is it, I mean, what can we do to make changes to bring that back? Because I feel like it's not the same as how we initially proposed, and we weren't given the opportunity to create a step-by-step process. And actually, when this idea was brought up, there was kind of a vision of how something like this could take place, but we couldn't include the process in the ballot measure because that wasn't how the process kind of worked. At least that's how it was explained to me. So I'm just kind of confused on that because I didn't think that would need to be included, and I want to know how like all of this happened.
Sure. So a couple things. First, we did involve IOLERO in developing the procedures for whistleblower. We were vetting those procedures with IOLERO, with Mr. Byers, as well as with counsel for IOLERO. And the procedures themselves would be, again, directed toward the intake of those complaints. The other point I would mention is the authority to conduct the whistleblower authority itself. That's the general authority that's established in the ordinance. And again, if you look at the ordinance, it's very general and does not lay out any steps to be followed. And that's, again, the reason for the procedures that we negotiated.
Thank you. Lieutenant Cutting, I saw your hand raised.
Yeah, I was just going to speak to, there was a question about timeframes. I think Mr. Rose asked how long it would take. So we have an agreement in the county that the investigative agency on the criminal side has the first 90 days. They have 90 days to submit their investigation to the district attorney's office. District attorney's office then has 90 days to make a decision on filing or not on the criminal side of it. The administrative investigation usually follows and utilizes a lot of the evidence that is collected through the criminal side before it's drafted and submitted. So from a reasonable time frame, it would not generally happen before the first 90 days for the administrative side, to Mr. Rose's question, before it would be submitted to IOLERO director for review, just as a general sense. It could happen faster, it could happen longer, but at least that first 90 days is generally what it takes for the criminal investigation to take place. Just wanted to throw those numbers out because I know there was a question about that.
Thank you, Lieutenant Cutting. Councilmember Pemberton, do you have additional comments, questions at this time? I do see your hand still raised.
Yeah, one of the things about the whistleblower complaint and the question of, this whole enforcement, this concern that there's no enforcement, is that shouldn't it be up to the whistleblower who gets the information beyond IOLERO? I mean, there's nothing in here that except for this proposed claim of confidentiality, which we all know doesn't necessarily work particularly well with whistleblowers. There's nothing in here that I'm not sure why I would make a whistleblower complaint under the procedures that have been set out here, because I lose control of everything. I, the whistleblower, loses control of everything once I give the information to IOLERO. And instead, IOLERO is compelled by these procedures to pass on information, and to pass on information before their investigation is complete. Basically, to pass on the very, very basic intake information, documents they receive, names of witnesses, and the actual complaints. So I'm not sure who this provision is actually meant to protect. I'm glad to hear that you say that they don't have to turn it over to the sheriff. That's an improvement over the way it reads. But I'm not sure who is supposed to, why somebody would do this if they lose control of all of this information.
Well, I'm not sure, Ms. Pemberton, Commissioner Pemberton, I'm not sure I'm following what you mean by losing control of the information.
This requires IOLERO to send the information elsewhere.
It authorizes IOLERO to make the determination as to whether there is a violation that needs to go or refer to the appropriate agency that would have the ability to do something about the allegation. And that's the primary reason for the language on referral, is to send the message to whistleblowers that if there is a matter that identifies alleged violations of rules in the sheriff's office, that IOLERO is going to refer it to the appropriate agency to do something about it. Right now, IOLERO has no authority to do anything about it. And I think that would send an even worse message to would-be whistleblowers if they feel it's, well, they'll look into it, but they can't do anything. So the idea there is to make it clear to the employees that if they complain about something that is determined to implicate violations of law, that it's going to get referred to the appropriate agency who has the authority to do something about it.
Doesn't the whistleblower have the opportunity to make that complaint directly to the enforcing agency?
Sure.
Yeah.
Well,
So,
I would say an individual has the authority to file a complaint where they feel it should go, but the law then determines what is to be done with the complaint. And what the voters decided here is they wanted IOLERO to be a receiving and investigative agency.
yeah, and there's nothing in here about how they're to conduct those investigations. Once the intake is completed, not once the investigation is completed, once the intake is completed, they are to make the necessary and appropriate referral of the complaint. That's way early on.
Well,
that is way early on in an investigation. And it doesn't make any sense for them to, why would they continue to conduct an investigation at that point? It just doesn't make any sense. I'm sorry.
I would just submit that in order to make a referral, you have to investigate.
But that's not what this says. It says, here are the 3 steps that you take. You take the complaint, you gather the documents, you get the names of the witnesses. And at that point, you make the necessary and appropriate referral. It doesn't say when the investigation is complete, you make the necessary and appropriate referral. It doesn't say you do that in consultation with the whistleblower. It says, it basically says you make the necessary and appropriate referral at the point early on in the early on. In other words, pass it off to somebody else.
Right. Commissioner, your point is well taken. I would just say that we look at it and interpret it differently, that IOLERO has the authority as an investigative agency to do that, to make the necessary fact findings in order to make a referral, to make a proper referral, and that there's nothing in the letters of agreement that limits that authority. That's the way we would interpret the language.
Mr. Sullivan, Councilmember Sullivan.
Yeah, I just wanted to kind of go back to this order of operations with respect to the investigations themselves. And we've been told multiple times that these agreements do not constitute amendments to Measure P or the legal basis underpinning IOLERO. But I'm still stuck on how that's possibly true. I mean, so again, like where in Measure P and where in the ordinances that apply for IOLERO does it say investigations by IOLERO don't begin until the sheriff's office investigation is essentially complete, which Lieutenant Cutting just mentioned looks like 6 months. Let's call it 6 months after they do their investigation and the DA's office does theirs. Where is that put down on paper before this MOU happens?
Sure. So it's found under section 2-394 of Measure P, 2-394 subpart B. And that's the provision that establishes IOLERO's powers and duties. That section was amended by the voters to add language that IOLERO has the authority and the power and the duty to review, audit, and analyze administrative and public complaint investigations. That's what the ordinance says. And then more specifically, under that general grant of authority, to the point about death in custody, the ordinance states, and this is under subpart H of that general section, where an investigation involves an incident resulting in the death of a person in custody of the sheriff, coroner, or results from the actions of an employee, IOLERO has the authority to conduct an independent investigation of the matter. So we read the ordinance as predicated on there being an investigation by the sheriff's office that IOLERO has the authority to review, audit, and analyze.
And did you again, I asked this question earlier, but did you refer to the people who wrote the ordinance to double check your understanding of it?
We
Or
did
no?
not. We did not.
Thanks.
Lorena, Vice Chair Barrera, I see your hand still raised. Was that from before, or did you have some additional follow-up?
Sorry about that. It was from before, but I did have follow-up actually. I guess from the point that Councilmember Pemberton just brought up and what we just heard, the interpretation of how something, a whistleblower complaint is referred is obviously confusing. And if I recall correctly, when we had our meeting in July, the explanation that interim that Garrett gave us, interim director Garrett Byers, kind of sounded like the same as what Councilmember Pemberton interpreted, which is also how I understood it. So I guess now that we're hearing this different interpretation, it makes it very confusing to really understand how we would be taking in these kinds of complaints. And it just makes everything that was changed, because things were changed in Measure P, very difficult to understand now. And I honestly don't know how to take in all of this. It's very frustrating. That's all.
Yeah, thank you, Vice Chair Barrera. I'm silent because I'm sharing in your frustration. It seems like a lot was done that concerned IOLERO and Measure P without really talking with the drafters of Measure P and without involving the community of IOLERO, as opposed to just the director himself. It feels like the voters and the people were left out of these discussions. And I understand, Mr. Bolaños, you had clients, namely the Board of Supervisors, with a task for negotiation. But it seems like in the attempt to get those 11 amendments back, other stuff that was important to the voters and to the drafters of Measure P was removed. And I think that's kind of where the issue and where the frustration is with many of the CAC members. With that being said, are there additional comments or questions from the CAC before we open this for our public comment? Okay, let's hear what our public has to say regarding this issue. I am going to open this to members of our public for public comment. When you are given the opportunity to speak, you will have 3 minutes. Please go ahead and speak when you're admitted into the room. Jerry Threet, you are first for public comment this evening.
Good evening. Thank you for the opportunity to speak. I realize I'm going to be repeating myself from the last meeting, but I think these points deserve repeating in this particular context. And I just wanted to start off by offering my thanks to Mr. Bolaños for his efforts at the Court of Appeal that, together with the ACLU's advocacy, brought back most of the provisions of Measure P. And I think we all should thank him for those efforts. I thought that the appellate effort was pretty skillful, effective, and it's largely successful. So that's the best thing. However, this evening, I think it's a different situation. There are a lot of things in Mr. Bolaños' comments that bear close examination. I just want to focus on a few points. First, I'm concerned because an agreement that includes ambiguity invites conflict, in my view, and with the deputies' unions, that invitation is very likely, in my opinion, to be accepted. We can see that in their decision to decline to join the county in a request to dismiss the PERB proceeding, since they now appear to hope that the Supreme Court will overturn the Court of Appeals. The supremacy clause in the agreement invites conflict. I don't think, in my opinion, it's crystal clear under a current state law precedent that a labor agreement cannot change a duly enacted ordinance. Certainly, there is case law from other states at the top levels of the courts that give mixed opinions in different directions on these issues. And I'm just concerned that we don't have clear precedent that's going to make this conflict go away. And I think significantly, the authority to independently investigate a death in custody or at the hands of a deputy is not in any way dependent on the sheriff's separate investigation under the plain language of Measure P, nor was it the intent of the ordinance. The alternative language of the two examples of independent investigative authority undermine arguments otherwise. So in the first example, it depends on IOLERO finding that an investigation is deficient in some way. The second independent authority has no qualifying language of that sort, and it requires reading into it by, in my opinion, cherry picking language from someone else to make a too precious argument to limit this authority. It's very clear in the absence of clear language limiting a provision like this that you have to look to the intent of the voters. The ballot arguments, the arguments of the two campaigns back and forth during the election all make very clear that the voters intended for IOLERO to have independent authority to investigate these deaths, not to wait on the sheriff completing its investigation until it begins such an investigation. So in my opinion, this particular provision in this agreement is illegal and it should be challenged in court. Thank you.
Thank you, Mr. Threet. The next person for public comment will be Elaine Holtz. Elaine, please give your public comment when you're admitted to speak.
Thank you so much. It was a great report, but it really confused me because I thought I knew what I was voting for. And in listening to this, I don't know what I was voting for. And I kind of agree with what Evan said when he said that there was very little knowledge from the public. I mean, I didn't hear about it till last month that even these MOUs and all this other stuff was happening. And I was never asked, you know, nobody was asked. And another thing that is really confusing to me, Mr. Balianos, I hope I pronounced your name right. I specifically remember, and tell me if I'm crazy, I specifically remember when Garrick Byers gave his report last month, he said he was not in any of these meetings. And that, I don't know if I heard that right or not, so I would like some clarification. And also, I would like to know what, I understand you represented the county. Who represented the people at that meeting? That I would like to know. And I'd like to know if there were any minutes that outline actually who was at those meetings helping to negotiate this process. Because this is all very confusing to me. I get the feeling like we're back in 2000 when the Civil Rights Commission made their report, like all of a sudden nothing is really getting done. There's a lot of mushmash going on, and I need a little more clarification as a voter and also as a person who is very, very concerned about this. So I would like to know if there is any way to find out who was at these meetings, who was negotiating for the people, and was it true that Garrick Byers said that he wasn't at the meeting? And I will take my answer offline.
Thank you very much. Let me just ask this, Mr. Bolaños or Mr. Byers, is there a way for the CAC to be provided with information regarding who were the participants of these negotiations and meetings, or is that confidential information?
It's not confidential information at all as to the CAC. And yes, we're happy to, and there are negotiation minutes. Okay. Extensive negotiation minutes, and the negotiating teams identified, and all parties to the negotiations are identified.
Okay, and hopefully we can obtain copies of those. That would be wonderful. Thank you. Garrick, if you could look into perhaps obtaining copies of those, I guess, attendance lists and minutes. I think the CAC would like to review those. You're on mute, Garrick.
I'm not sure the minutes were taken at some of these. I want to speak to did I say last time that I wasn't included in the negotiations? There was a caucus system that Richard set up, and I think he and I were saying basically the same thing last time and this time. In the room with the two unions, that was Mr. Bolaños or other people from his law firm. From time to time, Mr. Bolaños did consult with people like me, other people from the county as to how to proceed. And I did take part in those. Mr. Bolaños usually called them a caucus. I did take part in those. And I think I was clear last time in saying that, but not in the actual in the room negotiation. I remember one time I accidentally signed in and then I signed out quickly.
Okay, thank you, Mr. Byers. Josette, you are the next person to give public comment. Josette?
Hi, I can't help but feel a lot of doublespeak going on here tonight. And Elaine's recollection is correct about what she remembers from the last meeting. So I think the most important point here is that we as voters, we believed that simultaneous and independent investigation would take place. And our biggest concern here is that it seems to be sequential, that somehow the sheriff's department will do an investigation and then IOLERO will come in. And I think that that is the biggest area of confusion here. And I think that that's what concerns me the most. I also feel that I don't understand why the Board of Supervisors conducted themselves the way that they did. There was absolutely no reason, even though this was a labor negotiation, why they could not have negotiated and come to you as the COC before finalizing this for public input. Thank you very much.
Thank you very much for your comments. Christina Kramer, Ms. Kramer, will call on you at this time for public comment.
I did not know that I had my hand raised for public comment. I do not appear to have raised it, but thank you.
Sure. Thank you very much. I thought you had to comment for public comment. Thank you. Okay, Ellen O. Ellen.
Hi there. Yes, I'm also super confused and frustrated. My source of confusion, though, is really why the county decided to go forward with the negotiations in the middle of the litigation. Because of Mr. Bolaños's efforts, the Court of Appeal completely exonerated the voters, completely exonerated the county. There was only two little things that the Court of Appeal said should have been negotiated, and that was about the body-worn cameras and about interviewing union represented people. The fact that we're here now talking about, is there ambiguities in the Measure P about whistleblower complaints or when the IOLERO can investigate deaths of involving sheriffs is, this should not be happening whatsoever. Voters in California, voters are, what their will is sacrosanct. And I can't believe if this does now, if those MOUs go into effect, that any court is gonna okay that in light of the fact that the Court of Appeal said we won. Like we won and then we gave up stuff, just doesn't make any sense whatsoever. I hope very much that draft letter to the Board of Supervisors is absolutely perfect. Please, please, please submit it. And yes, Mr. Bolaños, if it does turn out that the PERB appeals in front of the Supreme Court, and then the Supreme Court in the likely event takes it and finds, yes, that they were right and we were wrong, then we'll have to revisit. But until then, there is zero reason why the voters should be giving up anything of what they wanted. Thank you very much.
Thank you very much. And yes, our next item tonight will be discussion of that letter to the Board of Supervisors. Next in public comment, Barbara Grisecci.
Thanks so much again for hearing my comments. I would just like to, affirm a lot of the other comments that I've heard. I'm not a lawyer, so I have no idea why an MOU would take precedence over the voters' vote, a 65% vote. That doesn't make any sense to me. The whistleblower change provisions also don't make any sense to me. Why would you, as a whistleblower, come forward knowing that your complaint could go to your management chain? And I also have no idea why these unions would not want to support their deputies. If a deputy is coming forward with a whistleblower complaint, do they believe they're lying? Is that why they don't want to support them? It is, to me, it's completely unethical. And I don't understand. They're supposed to be supporting their employees, and it doesn't make any sense to me. The other thing is the MOU, which has no end date, makes no sense. Measure P hasn't even been implemented. We're getting ready to implement it. I understand the purpose of the MOU, which is to describe how the implementation works. But to have no time frame when you haven't implemented it, where do you do the amendments if it's not working? It just makes, again, I'm not an attorney. It makes no sense to me. And then the last piece that I feel is really disturbing is the investigative piece in a death at the result of the sheriff's department. We had one this week, and I just want to go back, Mr. Rose, to your comments. If we continue to let the time clock go out, it just doesn't make sense. People lose their recollection. I have no idea why IOLERO can't sit in on investigations and do concurrent investigations as a way to be the citizens' oversight, not to monkey with the process, but just to be a part of that. And instead of having to like request files from the sheriff, they could actually sit in on interviews. They don't even have to ask questions, but they can hear from those witnesses. And that's a way to get at the citizens being a part of this, at an earlier point. And, particularly as these things keep happening, the sooner the public can hear that oversight is a part of that investigation, I think it's just going to raise confidence in what we're doing as IOLERO. So those are my comments, and I thank you very much.
Thank you very much. Carl Tenenbaum, you're up next for public comment.
I want to start by thanking everybody present for all their hard work and what they're doing. And for the commissioners, I think I echo a lot of the sentiments when I say that many of the commissioners have spoken, and all of the callers have expressed a lot of my thoughts about how confusing this all is. And Mr. Bolanos, I want to share Jerry's thoughts with the work that you've done negotiating. I get that you were tasked with this, but I also want to go back to Commissioner Solomon and thank him for clarifying exactly who you work for, because in the beginning, when you were describing what concessions were made, what giveaways were given, it sounded, with all of your words and everything, like you represented the Deputy Sheriff's Association. And what I don't understand is that IOLERO was created in response to misconduct, a storied history of misconduct by the Sheriff's Office. And as Ms. Grasecki said, 65% of the voters voted for this sweeping legislation to create this organization to investigate misconduct. And as it is now, the way it's been negotiated away, it sounds like IOLERO and all of the voters are just passive observers to what goes on with the sheriff's office. To wait for 6 months to find out about an officer-involved shooting, we're an independent investigative agency, IOLERO is, and just like we have faith in the sheriff's office to conduct an investigation, we should have faith in IOLERO to do a good faith, honest, and objective investigation. Why should they have to wait? And the last thing I want to point out to you, in the words of Alanis Morissette, isn't it ironic that you're telling us today at this meeting that we have to do this in a cooperative and collaborative manner, both parties, cooperative and collaborative manner? This sheriff's office has never cooperated or been collaborative in their efforts to bring any kind of justice, oversight, accountability, or transparency to the sheriff's office. And yet we're going to just sit here and say, well, we'll have faith that they'll do the right thing, when they never have. So in the words of many famous international terrorist negotiators, hostage negotiators, they say you never negotiate with terrorists. I'm not saying the deputies are terrorists, but I'm saying they lost at PERB. They lost at the ballot. And now it's time for them to realize that they have to make some concessions to have an effective oversight body for the sheriff's office. Thank you.
Thank you very much, Mr. Tenenbaum. Allegra, please join us for public comment. You'll have 3 minutes when we begin.
Thanks. Hi, sorry, there's white noise. Would you turn off the white noise? I am in the middle of doing bedtime, but I really wanted to comment and just say, I'm still very confused by the idea that the county had to go along with all of the demands of the Sheriff's Association and meet and confer, because that just doesn't happen with other labor unions, with actual labor unions. But it seems to happen with the police association. So it doesn't, that part just doesn't make any sense to me. And I also wanted to say that I really appreciate the questions on the part of the council tonight, and your skepticism around this, because the fact that this whole thing was like kind of interpreted independently of the people who wrote Measure P and the whole like emphasis behind Measure P, it's just not right. And it feels like the board is making decisions that are violating the will of the people without involving anybody who had any kind of interest in having oversight to begin with. And it feels like it's being done after the fact and undemocratically. And so I really appreciate that we are asking questions about this and not simply letting this agreement go by. Thank you for your time.
Thank you, Allegra. The next person up is David Eichar, E-I-C-H-A-R.
Hi, yes, I have to agree with Allegra that the public and looks like also the CAC, there was just a lack of communication of what was going on with this negotiations in for the MOU and the process that even needed to happen, that this is going to happen in terms of getting procedures in place, you know, that the public and looks like the CAC was just, you just didn't know, which was not, I think, not right. I think the Board of Supervisors, in my opinion, should have just agreed to a tentative approval of the MOU and then come back to the CAC and say, hey, look, this is what we've got. So you can go through then through the CAC and through the public to review it and come back and say, hey, we don't like this. This needs beefing up. This needs changing. And so, you know, I think that you may need to have an ad hoc committee if you can't agree with everything tonight, that everything that is either has some ambiguity or lacking in Measure P or that you disagree with in the MOU, it sounds like the CAC can go back to the Board of Supervisors, the Board of Supervisors and go back into negotiation to update the MOU. So let's look forward. Yeah, the past, it's the past. This has happened. Hopefully it doesn't happen like this again, but let's move forward and say, let's fix things that need to be fixed. And so we can move forward and have the true independent investigation as needed in a timely fashion. So it's like one speaker said, the witnesses, the people that interviewed do not lose the memory of exactly what happened and when. Thank you.
Thank you very much, David. Alcina Horstman.
Hi there, can you hear me?
Yes, thank you, Alcina.
Thank you. I just wanted to thank all of you on the CAC, really stepped up tonight, and I'm just really grateful because these questions are so important. And also to Mr. Bolaños, thank you, you won, but then I don't understand the MOU either. And I'm not a lawyer, I've been riveted to this, trying to understand it. I've been trying to understand it for months. I've read all of the facts that came along with it, and it's still very difficult to understand. So I really love everything that Carl Tenenbaum said. I agree with that in terms of the unions, in terms of, in my opinion, it's very disingenuous that about the working conditions in the first place. I mean, the whole thing, the PERB case was ridiculous in the first place. So I would really, what I don't know is, can the MOU be torn up? I'd really like to see that and then start again, because it's pretty outrageous. It's not working. We don't like it. We didn't vote for it. I guess I'll take my answer off the air. Thank you.
Thank you very much, Alcina. Lee, please go ahead with your public comment. You'll be permitted 3 minutes when you're able to speak.
Thank you. And yeah, thank you, Commissioner Zelig, and all of you on this commission. This is, yeah, we really appreciate you. It's become, I don't find this to be confusing. I find it to be pretty clear that there was absolutely no reason to negotiate things that didn't need to be negotiated, yet that was done. The legality of that has been questioned. The intention of over 60% of the voters, there was just zero reason to, unless you're not telling us something, but it sounds like, and from what I'm hearing and reading, that there was things, there were only the wearing of the camera, something around the cameras, which I'm not even going to try to go find right now, the wording, and then interviewing union representatives, but there was nothing about whistleblowers or anything else. So the fact that that was negotiated out is very clear, unnecessary and clear. So I don't understand the confusion. I don't understand why this even happened. I don't understand why the interim IOLERO director could have possibly let this happen when it was abundantly clear that the voters wanted oversight, from public oversight, separate from law enforcement. And here we are. And we're just going to keep being here until there's oversight. And I really appreciate all of you. Thank you. And I yield my time.
Thank you very much. Keith, please go ahead with your public comment. You're on mute, Keith.
Okay, there it is.
There
Hey,
you go.
you guys, great discussion tonight. There's entirely too much butt kissing going on. Okay. I used to think I was a mean drunk, and it's true, but now I'm sober. I'm absolutely 100% more direct. Okay. This lies in the fact, in my opinion, this lies in the fact that Eddie Ingram was elected with over 50% of the vote. Okay. That shows where most of the people in our county are thinking. Okay. And number two, the Board of Supervisors, in my opinion, then read the tea leaves and decided to make this deal on their own. Okay. And it just makes me sick. It's the advertisements on TV, vote for Democrats regarding President Trump, et cetera, et cetera. I feel like that's the only choice we have. The supervisors did this behind our backs, and obviously we need to get rid of some of them. And I know it's a long wait, but we have got to vote these people out if they're going to do this crap behind our backs. Okay. And I want to commend Ms. Pemberton, and also, let's see, I forget who else. I believe it was Tom Rose who also spoke up, or there was a gentleman who didn't. And I want to commend them for their comments and participation in CAC. But as far as the rest of you, I figure y'all ought to retire and just get out, and we ought to start over because you're not doing anything. Thank you.
Thanks, Keith. Let's go to Elaine Holtz. And then after this individual, there will be two more for this public comment. Then we're going to move on.
Hi, it's Alan, actually.
Hi, Alan.
I pretty much echo almost everything that the last commenter said, down to and including being more direct since quitting drinking. But I think that this is just a huge steaming pile of it, this MOU, because it goes directly against what 2/3 of Sonoma County voted for, and then went to court and then lost, but then we're making concessions anyways on it. And I just can't understand the point of doing that. It's like a fox guarding the hen house kind of thing if you're trying to protect the sheriff's department. Like, to make a bigger analogy about it, what it kind of feels like is, well, in the 2000 presidential election, Joe Biden obviously won, but Donald Trump and a lot of people on his side said, wait, no, you didn't win. This is wrong. There were things wrong with it. You didn't win. And then if the Democrats had said, like, okay, well then we'll make Mike Pence as vice president is a concession. That feels like what's going on here. And it's absolutely ridiculous, should be torn up. And any supervisor that voted for it should be voted out. And anyone on the board supporting this should be voted out, including for suggesting that we not move forward with some of these things because they might also be challenged in court. I said this at the last meeting, that we can't treat laws as whatever we want to just because we think they might be challenged in court, because then there's no laws. And we especially see that tonight after what happened this past weekend with the shooting, and then the reluctance on behalf of this board to do what the people have said, what 2/3 of the county said, that we want you to investigate this stuff, and say, well, we need to wait for more information to come out, when all the information that we need has come out. So I'm pretty furious about this, and I urge you to do whatever you can to fight this.
Thank you, Alan. Jim Duffy, and then we have one other individual after Jim. Jim, go ahead with your public comment.
Chair Zelig, members of the Community Advisory Council, thank you for taking my comment. I just have to say, it really strains credulity, and I think that's the right word, for folks to believe that these MOUs came out coincidentally on the exact same day that the Court of Appeals issued a tentative decision issuing largely a defeat to the Deputy Sheriff's Association and Scalia and Perb. It's really, and I'm not an attorney, but I talked to him, and it's almost unheard of for a Court of Appeals to issue these tentative decisions. And, they issued it because they were like, boy, you got a real losing case here. Do you even want to bother going to oral arguments? And of course they wanted to go to oral arguments. But at that same day, magically, coincidentally, that's when these MOUs that limit Measure P get signed. I got a bridge to sell you, if you believe that. So thank you for taking my comments.
Thank you, Mr. Duffy. And our last public commenter for this agenda item, Kelsey Vero. Kelsey?
Hi, can you hear me okay?
Yes, thank you.
Okay, thanks for taking my comment. And I appreciate the time that's spent by the CIC trying to dig into the complicated details and the questions that were asked, including, digging into some of the affiliations or appearances when people are being represented and who was there. I appreciate all of that. I agree with a lot of what has been said. I've been trying to follow this, and it is pretty confusing. And I think most people do not know that it's happening. And even if they did, they wouldn't really be able to weigh in very much, as many of us who try to weigh in regularly will note, that it's of much less impact than having voted it in the first place. And even the idea that the Deputies Association and other groups, including the Sheriff's Department itself, are the ones that are fighting Measure P's implementation feels very much like a dirty secret kept by the board and others, in terms of where this is at and what continues to be happening, and how public dollars may be spent in those pursuits, and all of the sort of shenanigans that have happened to put us here. And I agree with what was said about the labor unions in this case being just such a different case than most labor disputes. I mean, most of the time in labor negotiations, we're not discussing whether or not murder is allowed by employees. And I just think, I wish, and I don't know how this works exactly, but I wish that there was a way to have oversight that really kept the Deputies Associations in that place, like the Sheriff's Department, of folks who are not a neutral party in any way, and that negotiating, over the human rights of citizens and whether they are allowed to be violated is just not appropriate. And, we wish that the groups could oversee it in a truly independent way, and always, keep in mind that the, fox is guarding the hen house. So I thank you for your time on this issue.
Thank you very much. With Kelsey's comments, I am going to close public comment on agenda item number 4. The next part of this agenda item is possible action for the CAC. However, I believe that is directly related to agenda item number 5, which is the possible action that we have discussed taking. So I am going to close agenda item number 4 and open agenda item number 5 so that we can discuss the letter that was drafted, which is intended to be provided to the Board of Supervisors regarding the MOUs and these discussions that we've just had with Mr. Bolaños. We have a draft letter that's been drafted, and thank you very, very, very much, Councilmember Pemberton, for the initial drafting of this letter and for providing us with this draft. It's been provided to all members of the CAC and was included in our agenda items. Let's open it up to the panel to find out if there are any things that CAC members would like added, removed, or really just to discuss this. And ultimately we'll take public comment and then take a vote on whether we want to send this to the Board of Supervisors on behalf of the CAC. So I do see Councilmember Rose, you have your hand up. Let's start with you.
Just want to start with Councilmember Bailey and I met with our supervisor, David Rabbit, based on all the letters last month. One of his comments were, in general, you try to get the language as good as you can, but sometimes litigation follows, and the board pretty much leaves it up to the lawyers to litigate. And I think when they think that's done, they're pretty much thinking that's good. He was surprised when we gave him the stuff. He said anyone in his district that wrote those letters, he was going to respond. And he would like, if there's anything else, he would like more. With that as background, I strongly support us sending Councilmember Pemberton's letter as is. And I would hope, unfortunately, we only have 6 people here tonight, which is a quorum. So I trust everyone's going to vote to send it. And if not, I would hope someone would say, let's delay this vote for a month, not to delay more, but I certainly don't want this to get lost. And I know our councilman's looking for this, so that's it.
Thank you. And that's great that you met with Councilmember Rabbit. And yeah, it's interesting that usually the way it works is there's language that's written and then some litigation about fixing that language. And then we have an end result. Mm-hmm. The problem is this time that was done backwards. And they started with the litigation. And while the litigation was pending, these MOUs were being worked on. And it turns out the litigation was in Measure P and IOLERO's favor. But that really doesn't matter because there were side agreements being done at the same time. So it's great that that's normally the way it works, but it seems in this case, things went backwards or were being done concurrently with each other instead of getting the language done, litigating it to finding out if it's proper, and then knowing where we're at from there. Are there any other council members who wish to be heard on whether or not to send this letter to the Board of Supervisors, or any changes that you are seeking to have made? Okay, it doesn't look like anybody has a comment at this time. Nathan, I saw your video turn on. Did you have any comments?
Nope, no comments. I support the letter. I thought it was great. I'm wondering if there's anything beyond the letter that we can do as well.
Well, at this point, we're talking about approving the letter. What are you thinking as far as beyond the letter? What are your thoughts?
I guess I'm wondering if there's any, do we have any standing to contest the agreement?
I think these letters are kind of doing just that. This letter that we would be sending forward is essentially sharing our concerns with the Board of Supervisors and letting them know we're not satisfied with these MOUs and do something to correct it, do something to change these letters, do something to make modifications that were the will of the voters instead of the will of the negotiators. So I do think this letter, which again, Councilmember Pemberton is excellently written, I think it covers that. And certainly when we hear responses, you know, if there does become the need for further ad hocs or other additional, you know, steps, we can certainly go from there. But I think this is a great first step. Let me just open up to our council. If there's anybody who is opposed and wants to be heard, just to get differing opinions here, is there anybody who wants changes to or does not want this letter to be sent that wants to be heard? Okay, hearing nothing at this time. Let's open up for public comment at this time. Public comment will be restricted to the approval of the letter to the Board of Supervisors. I see one individual for public comment, David, more raising their hand. So David, go ahead. You'll have 3 minutes when you are permitted to speak.
Hi. Hi, can you hear me? Good.
Yes, thank you.
Yes, I think, you know, I spoke before. I think the one thing, and I just was able just to peruse the letter just briefly. And I think the one thing that you need to add in there is that if something needs to change, not just in the MOU, but also in the ordinance, that the Board of Supervisors should do that. Because as Mr. Bolanos explained, the reason behind the IOLERO and doing the investigation after the Sheriff Department has completed the investigation is because that's what's in the ordinance. Well, and of course, there's been some, you know, people's interpreting it differently, but if it's not clear, then we need the ordinance to be updated, it sounds like. And so I think the letter should be included specifically for that case of the independent investigation, that it can actually be done concurrent with the sheriff's investigation, not serially. Thank you.
Thank you very much. Barbara Grisecci, please go ahead with your public comment.
Yeah, I just want to thank the CAC for such a robust discussion tonight. I think there were a lot of concerns that were raised by the public, and I think I heard a lot of those same concerns from you, and I just so appreciate you being the voice of us on the CAC to IOLERO. So a heartfelt thank you. Also a thank you to Councilmember Pemberton for that great letter. I support that. I support your work. And I just want to thank you all again for your advocacy for us as citizens, especially people like me. We're not attorneys, we're not law enforcement, we're just citizens that really care. And this last week, we had a really tragic situation. So everything you do is so important to our community. And I just really want to thank you for all your time and service. So thank you.
Thank you very much. Bernice Espinoza, please go ahead with your public comment.
Yes, thank you for writing the letter. Thank you for speaking up and sharing the concerns that we have. I know that this topic was as to the letter, but it was also crunched with the other previous item about other forms of action. And so my comment is regarding to that. As Chair Zelig has mentioned, it seems like procedures were not followed as they normally would proceed. And so I'm wondering if there could be any inquiry or looking at due process violations that may have happened. And so that this letter may be brought up with some due process violation course of action if needed.
Thank you, Bernice. Thank you very much. Elaine Holtz, please go ahead with your public comments when you are admitted to speak.
I want to thank everybody for this robust conversation. You know, it gave me a little bit of encouragement that maybe some things are going to happen and are going to be done. I personally support the letter that Nancy Pemberton wrote. I think it's excellent, and I think it's very, very important that we bring this to the attention of the Board of Supervisors. And I want to just add one last comment, you know, because I was so involved with the Andy Lopez situation. I mean, we went to every single meeting for what was something 2 or 3 years. I can't even remember how long it was. And the biggest thing, the biggest discussion, the biggest resistance was to the word oversight. And that's what we as voters thought we were voting on, to give absolute oversight to a committee that can help to prevent some of these horrible things that happen. And here we are again with another shooting, another stalling. So I think it's very important that this letter gets taken up with the supervisors. And also, I just want to encourage the public that you have to turn up at the Board of Supervisors meetings. Otherwise, the letter becomes meaningless. If you're not there to support it and to voice your opinion like we did tonight, nothing is going to happen. And I really want to thank the panel. I think it's the committee. I think it's a lot of hard work, and it's a new day. You know, I mean, the world is changing and we have to go along with the change. We can't continue the same way. It doesn't make sense. I mean, just look what's happening. And here we are, a community in Sonoma County trying to change, trying to get some accountability, and look how difficult it is. So thank you. And thank you again, Nancy. That's an excellent, excellent letter. And I'm really proud of you. As a woman, you know, as a woman activist, I really, you are standing up, and I really appreciate that.
Thank you, Elaine, for your comments. Josette, you are the last person for public comment this evening on this item. Please go ahead when you're permitted to speak.
Okay. I also want to thank the CAC, and the last meeting was such an eye opener for me because I was not even aware this was going on. And I'd also like to thank Ms. Pemberton for all of her effort and the letter. I sent a letter immediately to all of the supervisors. The only supervisor who responded to me was Corsi. And all he did was point me to a packaged Q&A, which was basically worthless. And I tried to speak at the next Board of Supervisors meeting during general comments. And of course, I only had 90 seconds. So those of us who want to speak to the Board of Supervisors are not going to be able to say anything. So we are really counting on you. I write a column for The Sun here in District 1, and I'm kind of hoping, I don't know if it's not the right thing or it's not legal, but I'm hoping that Ms. Pemberton would agree to speak with me at some point, because the public is not aware of what's going on. There has been nothing about what's happened with these memorandum of understanding and Measure P. Thank you all very much.
Thank you very much, Josette. With that public comment, I am going to close public comments on this agenda item and bring it back to the CAC for action on this item. Specifically, I'm asking for a motion for approval of the draft letter to the Board of Supervisors regarding the letters of agreement with the Sheriff's Deputies Association. And it would be a letter, a motion to approve and send the letter to the Board of Supervisors. Is there a motion for that?
I move.
Councilmember Rose, that's been moved. And is there a second? I saw Councilmember Pemberton. Were you raising your hand to?
I'd like to second it and add a friendly amendment, which is just one line, which I would be happy to send it to Melanie before this letter goes out. And that's just as the second, this is to recognize the concerns of the community that we have heard both in this meeting and in our last meeting. So that after our first sentence, which reflects our concerns, to say our concerns are shared by community members attending our meetings on August 1st and July 7th. That would be the only thing I would ask to add.
I think that's a great addition. Tom, do you still move to move with that amendment?
Absolutely. I move with the amendment.
Okay. And Nancy, you're seconding with that amendment?
Yes.
Okay. Melanie, can you please take a roll call vote for the approval of the letter to be sent to the Board of Supervisors with the amendment as stated by Councilmember Pemberton?
Okay, Councilmember Bailey is absent. Councilmember Barrera.
Aye.
Councilmember Estrada is absent. Councilmember Flores is absent. Councilmember Pearl.
Aye.
Councilmember Pemberton.
Aye.
Councilmember Rose,
Aye.
Councilmember Solomon,
Aye.
Councilmember Chair Zeller.
Aye. Okay, so it appears that did pass. So Ms. Griffin, if you could please provide me with a copy of the draft letter with, or Nancy, if you could provide me with a copy of your letter with the amendment. I will finalize it with Vice Chair Barrera and it will be sent to the Board of Supervisors post haste. Okay, that will close item number 5. Opening now item number 6. This is the Community Advisory Council ad hoc reports. Let's hear from our community engagement ad hoc if there is a report.
I'm sorry, Commissioner Zeller, just to clarify, would it be fine for me to drop off now since I don't know?
Yes, Mr. Bolaños, thank you very much for joining us today. You may feel free to leave the meeting, and thank you very, very much for your explanations and for joining us today. Thank you.
Thank you.
Thank
Have a
you,
good
Mr.
Have a good
Bolaños.
evening.
Thank you, you as well. All right, so our community engagement ad hoc, I'd like to hear from you guys regarding the report out.
I think that would be me because Councilmember Flores is not here. She was
It would be
fantastic.
Tom, yes, yes.
She was fantastic. It was a giveaway for backpacks for the Hispanic community. There were approximately 400 people there. She reached out. We had at least 100 people take literature about IOLERO, what it does, and it was just a roaring success. We look forward to doing it more. If anyone knows any group or anything that's having kind of community things, let us know because our table was very well represented.
Great. Okay, that's excellent. Extremism in policing, is this going to be Max, Nancy, or Nathan?
We don't
mean,
have anything
basically,
more.
Yeah, I mean, we're
Go
all three in the process of getting the simulation tour and stuff with Lieutenant Cutting. So
Great.
we're sort of in process. That's
Yeah,
all.
I did attend the simulation training with Lieutenant Cutting. It was about 2.5 hours long. It was great. I recommend for any like CAC member to please, reach out to Lieutenant Cutting and he'll take you through it. It was very instructive and informative, and it was really good to get a tour and to spend more time with them. So I recommend it if you can.
Great to hear. Thank you. Okay, our policy recommendation and review group. This is Lorena, Max, and Tom. Again, if there is any report out for today. Tom, I see your hand up.
Yeah.
Oh, Lorena, sorry.
Would you guys like to report that we did have a meeting and I actually joined late, but the team handled it, so I'll let you guys take over. Tom? Max?
Or Max?
Sorry, very briefly, we've got a lot of new material from Lieutenant Cutting. We've drafted a memo that will go out to him since he's on vacation. It'll be waiting for him when he gets back, trying to clarify a few points as to our role in this. And other than that, we're glad we've got this, and it's all about the jail policy. It's 888 pages now, and it's going to be cleaned up.
That's great. So you guys are, that's great.
We did have instruction to review the campaign uniform policy. Did you guys want to talk about that?
I believe that's been put
Briefly?
off for a week. That's been put off for a week, right?
Oh,
Or
we're
for a
gonna have
month.
a full discussion later. Okay, we will have a full discussion on that later, but we have,
We've
we
drafted
did have a
something.
meeting to review that and have some talk about what was brought up.
Great.
Thank
That's
you.
great to hear that that's moving forward. I know that was something that we wanted to look at further, so I'm glad you guys are reviewing that. Thank you. Okay, I'll open up for public comments. Public comment would be only as to those CAC ad hoc reports. Alcina Horstman, please give your public comment when you are admitted to the room. You'll have 3 minutes.
Hi there. I'm not sure if we can ask questions to get responded to, but I'm just wondering if it's possible for members of the public to join any of the ad hoc teams and maybe do research or help out with any of those. And I would love to do a simulation training. So if you're not able to answer now, is it something that you could put out on your newsletter or something so that we could know how we could participate and support the activities of the ad hoc groups?
Yeah, I'm gonna have to look into that. I'm not sure if the public joins the ad hoc meetings themselves, but there may be a way to contact the individual CAC members to perhaps offer some assistance with their ad hoc reviews or research and so forth. I'm gonna look into that a little bit more and get you some more information about that because I'm guessing you're not the only one who may want to participate more fully. Councilmember Solomon, I saw you go off mute. Did you have comment regarding that?
Yeah, on the simulation training, we should ask Lieutenant Cutting if members of the public can do that. And I don't know the answer, but one of the pieces of feedback I did give him was that it would be nice to have this more publicized, the fact that it's there. And actually I suggested to him, and I haven't heard back from him, but I suggested that they record like one of us going through it and post it to YouTube so everyone can view it. And because it was really, like I said, really instructive. And I think it would be great for the public to see it. And obviously he can't take every member of the public through it. That would be unreasonable, but I think there has to be a way of sharing this information with the public more efficiently.
Thank you. Lieutenant Cutting, just curious question. Are those simulators open to the general public in any way by appointment, or is that something they'd be able to do with you?
So no, currently, it's a very time and labor intensive system. It's also in use in our regular patrol training schedule. So the limitations on it, especially this quarter, are very low. It doesn't mean that we can't. We do have the Citizens Academy that the sheriff puts on, and that is a piece of the Citizens Academy. I think I'll have to look at the schedule as to when the next Citizens Academy is starting. I'll get that out to Chairman Zelig, and he can put it out on a CAC panel as well. Other than that, I did receive Nathan's comments and feedback on that. I am looking at it. I don't know what the best way to present that is so that the viewer gets the same thing out of it as the participant. But that is something that I am actively looking at. I just don't have the answer tonight for that.
Thank you very much. Melanie Griffin, I see your hand raised. Is that regarding this issue as well, the ad hocs?
Well, it's just regarding the expressed interest in joining the ad hocs. We do have an at-large vacancy for the CAC, and we have a vacancy in District 3, I believe is Corsi's district. So we are going to open those soon to accept applications if there's anybody in this group that's interested in joining the CAC that way. That doesn't answer whether you can participate in the ad hocs without being a member of the CAC, but just something for people to keep in mind and to share with people who may be interested. If they know somebody who might be interested in those, we would likely leave those for the new director for the at-large appointment. Of course, the other one goes through Corsi's office. But just a reminder.
Great, thank you very much. Okay, I am going to close agenda item number 6 at this time. I'm now opening up to agenda item number 7, requests for future agenda items. Ms. Griffin, one of the items that we had mentioned was please put on September's agenda an update regarding this most recent sheriff-involved shooting and the recent death by sheriff's officers. We want to follow up on that to see where the investigation is at that point, and just have that as one of our agenda items. Are there any other agenda topics that individuals on our CAC would like mentioned at this time? And keep in mind, if you don't know of something now and you think of it, please email us, because we do have agenda planning meetings where if you have some ideas, please send them to us so we can discuss what to add for September. Any other thoughts on additions besides the update or progress regarding the most recent shooting? Okay, we will of course have an agenda planning meeting and discuss further items, but for now, that's the one that we want discussed. I will open up for public comment on this item. Again, requests for future agenda items. When public comment is open on this item, you will have 2 minutes to give agenda future item public comment. Jim Duffy, go ahead when you're admitted.
Thank you for taking my comment. Real quick, I'm just requesting that that item be listed as a potential action item in case things go sideways so that you guys can take action and you don't have to punt it for another month. Thank you.
Mr. Duffy, thank you, because you will notice that as a result of your suggestion last time, most of our substantive agenda items now do have possible action items by the CAC. That is something we intend to continue going forward. Our substantive agenda items will have possible action by the CAC for that very reason. Kelsey Vero, please go ahead with your public comment.
Hi, yeah, my name is Kelsey. I guess this is a small thing, but it feels very relevant every time a shooting happens. And I'd rather, that oversight was done in such a way that it doesn't happen. But in the meantime, I'm wondering who controls and what limitations are there or requirements are there on the language that is used in the representations to the public and press, detailed as
Kelsey, I'm sorry, we lost you. We can't really understand what you're saying. Yeah, I'm sorry, Kelsey. We're
happen
not,
or after an incident happens. I think a lot of us have it basically is like euphemism.
Kelsey, I'm sorry, we're not able to hear you. You're cutting out too often. And I'm sorry, we're not able to hear your request. Please email us and we will discuss it at our agenda planning item and add whatever you were talking about if it's something we want to add, but please email us. Keith Reinhardt.
Thank you. And I want to say that if I left anybody out who truly has their heart in the CAC and is really trying to make change, I apologize if I didn't mention you personally as a valued member of the CAC. Now, number two, could we put on the agenda, and it isn't really an action item, I don't think, but can we get the feedback from the supervisors, anything that we've learned in the forthcoming month, either as a result of sending a letter or of discussions with the individual supervisors? Could we get like some feedback from you guys on what you may have heard?
Yeah, Ms. Griffin, if you could add that if feedback is received by our supervisors to report that back. Yes, thank you, Keith. Anita Lafollette. Lafollette? I apologize if I'm not pronouncing your name correctly. Anita. You're on mute, but go ahead and take it off mute and you can go ahead and speak to us. Anita, you're on mute.
Okay, now, okay, can you hear me now?
Yes, thank you.
Thank you. I came to this meeting tonight especially because there were a couple of incidents that had been reported. Oh, and because I'm in homeless action also, and so we have a couple of incidents by homeless people that were reported, and I wanted to make an IOLERO report like I did previously. Is that with the same procedure, or do you need to put that on your agenda to make a procedure whereby people in the community can contribute?
So Anita, if you are wanting to make a report to IOLERO, you can either do that by calling IOLERO or by emailing IOLERO and letting us know the report, and the people at the IOLERO office will always respond to you to take the information from you about the incidents and about whatever it is that you wish to report. So either call the office or email, and any report made to IOLERO will be handled in the proper way.
You got that, Melanie? I sent you an email, but I wasn't very specific, and I'll get back to you with more information.
Let me look. I did get an email. I got 2 emails from you. One really didn't have anything attached. And then it looks like you resent it.
I'll call you tomorrow. Are your hours 8 to 5?
Yeah.
Okay.
Thanks, Anita.
I'm sorry to bother you with this, but I didn't know if it took an agenda item or not. And thank you for all the hard work. I've been listening the whole time. I'm very involved, and I think you do a marvelous job, and keep it up. Although I do agree with some of the complaints. Thank you.
Thank you, Anita. We appreciate it. And yeah, for any complaints or reports to IOLERO, no agenda item needed. Just please call the office during the business hours and leave a message if we'll always address that. Ellen O, go ahead. You'll have 2 minutes when admitted to the room.
Hey there, I'm assuming that you're going to get back to Kelsey, so I won't do that. But I just want to ask that you put on next month's meeting that we actually get the status of the MOUs, because I feel like the community has no idea. Like, well, a lot of people have talked about this, but community has zero idea that, you know, things were changed from what they voted on. And to get like to find out what happens, the status of the letter that you send and anything else, to actually get like where we actually are, to make sure that we know, like the voters know, like for sure that their voices were heard and are respected, and if not, so we know what to do. Thank you.
Thank you very much. And the last person for public comment is Kelsey. Kelsey?
Hi, thanks for taking my comment again. I was in the car, but I'm home now. So my question was about, about putting on the agenda the language that's used in incident reports and press releases and things that come up because we know information is coming out, and a lot of it's not available yet. More of it is available to the sheriff's department than it is to anyone else, like the press. And yet the language used in incident reports seems very slanted, and euphemisms are used. And, you know, I mean, I just don't know what controls that. Are there rules? Are there limitations? How are things represented? Can it be affected in any way? Because, you know, the most recent one was a perfect example of, like, you know, if you went and looked at the comments under their incident report, it was so like, well, he had a weapon, it says right there. And then a lot of people never follow up or see it. And, you know, I just, even when it says things like the word appears, it's just not very clear. And it feels like it follows a formula that's well worn and intentional. And I just wonder if there's anything we can do to increase transparency there and maybe ensure that, you know, certain language is clear.
Thank you, Kelsey. I appreciate the public comment. Okay, with that, that is good information for us to use for our future agenda planning items. I will close agenda item number 7 at this time and open up number 8. This is going to be public comment. This is public comment for items not appearing on today's agenda, but within the subject matter of the CAC. Please state your name and who you represent. This evening's public comment will be restricted to 2 minutes, and we will open that up at this time. Mr. Duffy, Jim Duffy, please go ahead when you are admitted to speak.
So I want to thank you all for an excellent meeting, and thank you so much for toughing it out for 3 hours. I think you should reward yourselves with a party, and I think the party should be to welcome the new director, who apparently is going to be coming in probably right around the time of your next scheduled CAC meeting. There was a reception given for Director Threet when he first came in, so members of the community could meet him as a human being before they started beating him up at CAC meetings. And that courtesy was not extended to Director Navarro, to my memory. And she came in and made some faux pas in her first meeting, and, you know, it really hurt her. And in retrospect, looking at it, she would have really benefited from, you know, a reception saying, hey, this is the new director. People who are interested in this stuff, come and meet her. So whoever the new director is, I think you should push to have a reception for them before they get thrown into the fire. Thank you for taking my comment.
Thank you very much, Jim. Appreciate it. That is all the public comment for this evening. I'm going to close agenda item number 8. And with that, I will adjourn this meeting of the CAC. Our next meeting of the Community Advisory Council will be held on September 12th, 2022 at 6 p.m. Keep in mind, we are aware that that next meeting is during the same time period with the NACOL conference. If the CAC members are attending that conference and will not be available, please let us know so we can make sure we have enough members to continue. Also, if you will be going to that conference and want to join from the conference, please let us know so we can make sure you're able to do that. But our next CAC meeting will be held September 12th, 2022 at 6 p.m. by Zoom. And with that, thank you very much to everybody who joined us this evening, and we will see you next month. Thank you.
Thank you.